Close enough. I call to order the November 18th meeting of the Los Alamitos Planning Commission. I'm called to order.
Chair Riley.
Here.
Vice Chair Quilty. Here. Commissioner Andre.
Here.
Commissioner DeBolt.
Here.
Commissioner Gross.
Here.
Commissioner Lowe.
Here.
Commissioner Sobelkamp.
Here.
Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America
And to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
That brings us to oral communications. At this time, if there's anyone present who would like to come up and speak on an item that's not on the agenda, this would be the time to come forward and do so. Right, seeing no one come forward, I'll close oral communications. Move on to approval of minutes, which we have none. Consent calendar, none. Staff reports, none. Item 8A, public hearings. Zoning ordinance amendment number 15-07. Staff report?
Thank you, Mr. Chair and members of the Commission. Good evening. Tonight we have before you a draft ordinance that alters our code in response to three different sets of legislation that the governor has recently signed regarding not medical, but cannabis, I guess, is the best word to use for a general term. So what the city is doing is exercising its rights by making sure that we zone accordingly and regulate accordingly prior to those laws taking effect. One which has a very significant deadline of March 16th as it takes effect, that if a city doesn't have that ordinance in place, the state governs. If you look at the draft ordinance, the ordinance has several prohibitions in section 1739.020, and I'll read the main parts of those prohibitions. Is no person shall establish, operate, conduct, or allow a commercial cannabis activity anywhere within the city. No person shall conduct any deliveries that either originate or terminate within the city. Accordingly, the city shall not issue any permit, license, or other entitlement for any activity of which the state license is required under the MMRSA. And further, no person, including a qualified patient or primary caregiver, shall cultivate any amount of cannabis in the city, even for medical purposes. Now, our city attorney has drafted this ordinance in response. She, myself, the city manager, and a number of our peers across the state have participated in webinars on this topic to make sure that we're prepared in advance for this. In order to adopt this, it would take action by the Planning Commission tonight. Then it would move to the City Council for a first reading, second reading, and then 30 days later, it is good. So we have to meet that March deadline, and we would do that if we stayed on topic. I've invited our Captain Rick Moore here for you tonight to give you a police perspective if any of you have any questions regarding enforcement or the kind of activity police agencies are involved in enforcing such laws, or laws that are enforced when they're not on our books, such as especially transportation of marijuana for cities around us that may end up permitting them. We don't know. So we brought them here tonight. With that, it is a public hearing. It's required for you to have a public hearing, take any public testimony, then discuss amongst yourselves, provide us direction, or pass a motion to approve and move this on to the City Council through adoption of the resolution. With that, Lisa's here for any questions, and again, Officer Rick Moore is here if you have any questions.
Right, anybody have any questions or comments for staff? All right. So with that, I'll open up the public hearing, see if anyone wants to come forward and speak on this. Please state your name
Wayne.
and address. Or what do we usually ask for?
Sign in.
Yeah, is there a sign-in sheet there?
Yeah.
That'd be fine.
What do I put for agenda number?
8B. 8 or 8A.
Yeah.
8A is an apple?
Okay, we'll
I'm
figure
looking
it
at
out.
tomorrow.
You're the only person here, we'll remember.
Yeah, I'm kind of disappointed. I thought there would be more people to talk on this subject, but I mean, I guess most people don't care about it, so. My concerns is why you guys would put prohibitions in place for the entire thing. I mean, money aside, revenue aside, the safety and security of the people of the city having to travel out of this community to get it, having to depend on somebody if they can't travel out of this community, making it illegal to deliver to a person's house who can't get out and do it. For somebody like me who has to take somebody out, I mean, I have a full-time job, I have a family to take care of. Taking care of a person on the side that needs this, I'm not quite sure why you would put the citizens of this city in such distress. I mean, you're making it difficult on them to support people with cancer, people that need this. I've seen firsthand that people with cancer, it gives them a will to live, it gives them an appetite, it gives them a reason to want to go on every day. I mean, cancer is a hard thing to fight. And if you're depriving these people of their legal right to, under the Compassionate Care Act, to have this, I don't quite understand it. So, I mean, that's my piece, but not that it means much.
Okay, well, thank you. We appreciate your coming forward and sharing your comments with us. All right, seeing no one else come forward, I'm going to go ahead and close the public hearing and bring it back to the commission for discussion. Comments, questions, discussion, anybody?
Captain Moore. Hi there. On a police perspective, what problems do you see with it for transportation in the city when having it delivered?
In 2013, our robbery rate doubled due to a business delivering marijuana to the city. There were 6 different robberies that occurred from a variety of marijuana delivery services being called to the city, at which point they were robbed at gunpoint, and which is one of the most serious crimes that we have in our city, shy of a homicide. That's just with the delivery aspect. Marijuana sales is typically a cash industry, which provides another target if we were to have, storefront locations, which typically keep a lot of cash on hand. But in 2013, we had a total of 11 robberies, 6 of which were marijuana related. So that's my concern is these drivers are, typically are carrying cash, they're carrying amounts of marijuana, and there's no way for them to vet the potential customers that they're coming to, their clients they're coming to meet.
So was it the client or customer themselves that was
No,
doing the robbery, or somebody was waiting for them to
it's
make the
somebody that
delivery?
had phoned in the order, requested them to come to a location.
Uh-huh.
They weren't residents. They were in fact out of LA County. They would just wait there, and when the delivery driver would arrive, the 2 suspects would approach him, put him at gunpoint, take phone, wallet, keys, money, and marijuana.
So these alleged criminals came from LA to a residence or a business address in Los Alamitos?
Multiple residences. It's because it's a nice community. We don't have that type of crime here. Delivery drivers felt very comfortable delivering to our community.
And this happened in residential neighborhood?
Yes.
So they're not actually, they're just using that address, they're out front, somebody shows up.
Right. Yes, sir. They're just calling in an address. I'm at 3862 Green, and they may be next door watching. They see the person drive up. They come out, approach them, and they moved it Green, Howard, Reagan, Florista were some of the streets where the robberies were committed.
Were they ever apprehended?
They were.
Was it the same 2 people?
Yes, sir, it was.
Okay.
They were part of a larger criminal network in LA.
doing the same thing.
Yes, sir.
So since 2013, we haven't had any other situations with regards to that because it was basically based on those two guys.
Yes, sir, not as significant. And oftentimes, after reading the report, because I wasn't personally involved, the different delivery services did not want to state why they were in the city. And that's when there were two within one night, one of the officers asked, "Why are you in the area?" And the story kept changing, at which point it drew the officer's suspicion. He separated. There was two drivers in one incident, or two employees, and got one of them to admit they were delivering marijuana.
Which at the time wasn't illegal, though, was it? If they had if the person calling had a medical marijuana card, that would not have been illegal in
No,
our
sir, it wouldn't.
city at that time.
Correct.
Any other questions or comments?
Is it, I don't know if this is within the scope of what we're talking about, is it illegal in the city to use marijuana if you don't have a card?
Well, it's an infraction now.
Okay, and if you do have a card, do you have to be in your residence, or can you be out on the public right of way? Can you be,
I don't believe there's anything in the current regulations that specify that you have to be in your own home if you're somebody authorized under the Compassionate Care Act.
Would you do one more thing, just in case, since this is being taped, would you define infraction?
The lowest level of crime in California, you have felonies, misdemeanors, and infractions. And infractions are typically citable offenses.
To put that into some more lay terms, your traffic tickets are infractions.
But
It's just a pay
But
ticket.
does that not also have a little bit to do with the amount on the person? I mean, if it was over, let's say, an ounce or whatever the amount is for, I think medical marijuana is an ounce, I believe. If it was over that, is it still an infraction if they have a half a pound on them?
It depends on, well, I would defer to the.
I
to the
think
attorney.
you're right, it's an ounce or under makes it an infraction if you're not somebody authorized with
You
a
don't have
card or.
Right. Well, actually, in California, if you don't have a card and you have an ounce, it's still,
An
well, that would be an
infraction.
infraction. But
An
if it's
infraction.
over an ounce, it would be, whether you have a card or not,
misdemeanor.
I believe it's a misdemeanor, correct?
I would have to look into that. I'm not that familiar with the laws on this. I think
what I
that's
read,
right.
some of the
But I
stuff that I was
think
reading.
that's correct.
Okay.
And I think it's important to note, to actually get a medical marijuana card is very easy. I've had peers in my training program that are highway patrol officers that teach the DRE program that walk in a CHP polo shirt and say they have, he had appetite issues, and he was issued a medical marijuana card. He went to another place and said he had chronic pain. He wrote a check and got his card within minutes wearing the same shirt that had his first initial, last name, and his badge number on it.
Unfortunately, I don't think that part's going to change.
Probably not.
Well,
The other issue, I guess, which we don't have the crystal ball, but several states have already gone ahead of federal regulations and made legal the recreational use, which is different than actually a card.
That's correct.
I mean, a card.
Colorado.
Washington, yeah, so there's a few, but still, that's, federal hasn't gotten on board with that yet. If at some point, and I'm just asking this so I have clarity, if at some point that the federal government decides to go ahead and say, we're gonna make recreational legal for everyone, how does that affect, I mean, obviously, if this ordinance is passed, then it is in play that we are not cultivating dispensaries or anything like that, but it doesn't really preclude people from then using recreational marijuana within the city, correct?
It would depend how the federal law were to be written, that if it retained the land use authority like the state law does, which very clearly says to engage in any of these commercial activities, you need a local permit in addition to a state permit. So what types of activities would depend how the federal law was written. If they said smoking it is legal, then I think, you know, if, and California still said it wasn't legal, again, it would depend how it was written, because right now recreational marijuana isn't allowed in California. You know, see the results of the 2016 ballot initiatives on that one. I understand there are about 3 different bills or initiatives out there to put it on the ballot.
Right, that's what I heard. That's what I read anyway, too. You mentioned, I just want to go back, you mentioned, I think in 2013, there were 11, I believe, robberies that were recorded in that year. Is that,
That's correct.
were the others, did it have any relation to, say, what were the other, do you by any chance remember what the other
They
ones?
weren't related to marijuana deliveries. A robbery could be me, you know, give me your cell phone.
Sure. Any relation to, like liquor store type robberies or anything like that? Or have you seen that in the last couple of years? Have you been called to any within the city?
Oh, we've had robberies, but the numbers are typically very low.
Okay.
All right, anything else?
I was just curious. Well, first off, I spent some time over at the hospital this week, and while I was there, I asked a few of the nurses what their thoughts were on the various subject, and they came to me, and they were kind of in favor of having some sort of form of facility in the city. And I was just wondering, from the medical center standpoint, I'm assuming they haven't commented on it at all, but any comments from the medical center? So we have a huge hospital here. You think they would maybe have some interest? I don't know. Maybe not. The pharmacies in the medical center that would possibly get involved in this, but
And no one commented based on we put an ad in the paper and no one commented based on it, so.
From a provider standpoint, there is no true benefit for the majority of these people, and I would say the major majority of these people, for marijuana. We see some negative long-term problems coming up with neurologic disorders and onset of early Alzheimer's, especially in the younger group using this for what they consider general anxiety disorder, insomnia, I have asthma, I have a cough, and this is what we're getting. I get a lot of things that tell me this is a misuse of something that if you're using it for a person who is in a terminal stage, some of the oncologists will write it for the terminal patient for a euphoric feeling that's brief-lived for them, along with some of their pain medications. But there's a lot of these physicians, as well as a lot of our providers, that will not and want nothing to do with it. The cards, a lot of the cards that are written, half of these people that sign their name to them never even see the people who walk in the door to get the card. So if I'm looking at it, do I see a reason for a dispensary? No.
would you also...
Pharmacy too does not see the benefit.
Gotcha, but wouldn't you also, I think it's a fact that the most abused drugs are prescription drugs
Absolutely.
by far. So,
And alcohol, which is
And
legal.
therefore, if you really look at what's going on right now in the DEA, there's a major push and clamping down on the use of your prescription scheduled drugs and more justification. So you're actually seeing people having to either pull back on writing or justify it to the DEA.
yeah. What I'm saying is that the abuse of prescription drugs would be just as bad or far outweigh the abuse of medical marijuana.
Well, the
In my
difference
opinion,
would
I think.
be where the problems that we see in the drug you're probably really referring to is more in Vicodin, and you're actually seeing a higher rate of suicide and misuse. Okay, that is very true.
Oxy.
In marijuana, we're seeing other things from accidents, the same suicidal ideation. We're seeing the neurologic disorders. So we're seeing the things that are costing us more money in the medical industry and driving cost. And
I
don't
think
mean
we're
to
all-
sell
I
the
thi-
gut you're short. I don't mean to make what your situation is with your family.
Well, I think-
Misinterpret what I say.
I think we're all pretty aware that there's a ton of misuse of
Yeah, you
a
can't
medical
have
marijuana
alcohol.
card at the moment. There's a ton of it.
Mm-hmm.
But, as the gentleman that spoke, there, and as you mentioned, terminally ill patients, there is a valid use / prescription for cannabis. And that's
But
where.
do we need it in this town?
Well, that's the other part of the question
Yeah,
that
just-
I'm asking. But,
Well, that's the other
I mean, it is a very small city.
Mm-hmm.
It's almost a pass-through city, if you will. If you look at Catella, that's pretty much what most are doing. You know, I looked online, I checked. There are dispensaries just probably within, I would say, 3 to 6 miles of us, either direction. You've got Stanton, Buena Park, Garden Grove, Long Beach, all with dispensaries in their cities. And then also there are delivery dispensaries, if you will, as you mentioned, Cerritos, and also in Long Beach and Stanton, they have, you know, delivery type stuff. So it's not that people couldn't necessarily go 3 to 5 miles away and still get it.
That's fine.
Right. I don't necessarily have, the only issue that I really see with ordinance for me personally at this point is the delivery aspect. I appreciate that information too, because that's very helpful. Everything that I was reading as far as studies and actual substantiated evidence, where they actually received grant money and did research on this topic of how a dispensary affected a city, everything that I could gather basically showed statistically that crime went down where a dispensary was placed. But I'll preface that by saying that there are also some instances where zoning played a part in how they zoned where the dispensary could go. So if you put the dispensary in the lowest economic status area of your city, where there already is crime and problems, you're probably not going to see a decrease there because you've already got other issues going on. But typically with the heightened security that people are aware of, the cameras, sometimes security guards within these dispensaries, all of that actually brought crime down in that respected area in and around the vicinity of that. So it was interesting to see because the cities would portray, possible effects of a dispensary. Most of it was listed as possible effects, meaning they didn't really have any evidence. They just said, hey, this can happen where you have, crime can go up, or, solicitation, different things, people trying to sell outside the facility for a cheaper amount, that type of stuff could possibly go on. So, not saying either that necessarily that's what we need for our city, but the only issue I do have is the delivery portion, only because there are people that truly do need this. There are many that don't. There are some that do, and it becomes, in many instances, not only a major inconvenience, but to some degree maybe not possible for them to actually travel outside of their area, close area, to get it.
That's not all true, because there is a way around that. However, the delivery aspect I have, that goes into just the crime element here, but at some point, the person who's going to be the victim will be the poor child in the street who happens to be at the wrong place at the wrong time. That we hold to this community, that we have to be cognizant of the fact that there is that high risk. And there is a risk of robberies, there's always a risk of anything, I get that. But we're increasing that risk if we say, okay, you can deliver, but you can't do any of these other things. That, to me, is enough justification to say no on delivery. People have a way to get this. They truly
Well, whether
do.
we set this ordinance or not, the people that don't have cards are going to continue to get it by their
But we're
means
not
and ways
worried
that they're
about
going to
part.
do
What
it.
we're worried about is what we can set a standard in this community, saying that we don't want to have shops, we're not growing it, we're not doing deliveries.
I understand that.
That's all we're looking at. We're not looking at who has cards, who does what with it, or how they obtain it. And most of the oncologists that I know actually have a preferred dispensary that they have their clients go to that are in end stage.
Correct. Again, I think it goes back to just taking a look at, I agree with you also. I'm not saying that I'm for or against. I'm trying to put some points out there so we can have a discussion about this. But having it 2 to 3 miles on either side of us really doesn't make a difference. Now, as far as having one in, say, let's say this doesn't go through, there is a dispensary that opens up in Los Alamitos. For somebody that lives over towards the Stanton area, it's very highly unlikely that they're going to come in all the way to Los Al when they can go to a place in Stanton. People that are in Long Beach, very unlikely if they have them around them. It's no difference than a pharmacy. I mean, look at how many pharmacies we have just in this given city alone. I mean, how people don't want to go more than a 3-minute ride to get their things that they need, whatever that may be. So that's all I'm saying. I mean, whether we have it in our city or not, it doesn't mean that people are going to stop or it's going to increase or decrease. It's, again, like I said, more of trying to find out, helping out those people that actually need it.
Yeah.
Okay. Trying to get back to, I think what delivery is a part of it, but I think if we look at the summary, what we're trying to do is, tonight, is to get the city, I think, into a position where we have the ability to control our own, set our own regulations.
Versus the state.
Versus not doing anything. So we're kind of under a time constraint.
For sure.
And I would say, like you, of all the in here, delivery is the one that I have I'll say the concern about in trying to reconcile a prohibition against delivery with the compassionate care portion that we've got enacted in the state. Okay, but I don't know that we need to do that right now. I mean, I think we have to get the framework in place so that we have the ability to do that, if I'm understanding what this is all about, okay? And so that, if we can wade through everything and maybe even, I'm of the opinion this is pretty much it's almost like a housekeeping, I don't want to say a housekeeping, but it's something that we need to do to get us into the position to really get into maybe lengthy discussions if we want to revise it or change it. Correct? Isn't that kind of where we're at?
Right.
And that's why we're having a meeting, today instead of, because we're trying to meet a deadline.
The
Right.
law doesn't say that if you allow it now, that on and I'm sorry, Steve's right, it's March 1st. Got the 2016 part, thinking the date was the 16th. But the law doesn't say, well, if you allow it now, then you get to ban it. But I think it is clear the other way. If you ban it now, you can later come back and make it looser
Right.
and say, well, we've determined that delivery should be allowed at this point.
Well, and that's the other, I mean, if you look at all of this, it's all relatively new. All of the research, I mean, it goes back to, medical marijuana goes back, but as far as dispensaries and, you can look back to around 2005, 2006, where things started you started seeing information about it. That's really not that long of a time frame or a gap to really have a good understanding of the cause and effect of this stuff. not marijuana.
One
but
thing I want to
dispensary.
clarify is you're talking about dispensaries in other
Dispensaries.
cities. That's not a delivery service.
No, it's just one aspect of
Yeah.
the ordinance. No, I understand. No, delivery is a guy in a van. I understand.
Okay.
Bringing it-
I just
Well, it's
wanted
not
to-
only a guy in a van, it's anybody bringing it in, isn't it?
Well, that's what I'm saying.
The way this
Somebody
is-
bringing it into the city, bringing it
Anybody.
into
So
the city.
including a
Well-
caregiver, if a caregiver were to drive over to and
I-
pick it up and bring it back.
No,
I
I'm
don't
not,
think that-
I don't think that.
I don't think that
would
relates.
be covered. I don't, that.
You're talking-
That's not
We're
a
talking
commercial.
Commercial delivery
Fine, okay.
service,
Then
yeah.
Yeah, then I'm let's just,
Yeah.
okay, so if we,
That's a guy with a,
right.
marijuana leaf on the
This
side
I
of his
think,
van coming into
I
town.
think we can take the, if we, as the attorney was just mentioning, if we can take the broad, we come in and narrow it down tonight, and then we have the ability to loosen it up later, or recommend. It's not our decision ultimately, it's the city council, and they
Right.
could have a whole different
Right.
take on all of this. I mean, the way it's been presented, at least my understanding is we need to do this. If we're going to do it, we need to do it in order to provide the city with the future ability
Yes.
to weigh in on this.
That's pretty much what they were
Okay,
saying on the
and so
webinars.
it's not like this is all locked in concrete.
No, of course not.
Okay, and so, just so in the interest of trying to
I mean, it's a zoning ordinance, just like we're amending
Yeah.
all our other zoning ordinances. You can
Right.
come back and look at this, but the way the statute is worded, it's not clear that you could go and ban it after March 1st, 2016,
Right. You probably
on the delivery.
can't.
Okay, that's actually really
Or-
helpful information.
I'm sorry, on the cultivation.
Okay, so, if I can, so then, if we can get into it, into our attachments, and I just have some questions on the language. When we talk about, in attachment 1, the resolution, we talk about, just in the title paragraph, adding chapter 7, 4 sentences down,
I'll go for number 3.
prohibiting all commercial medical marijuana uses in the city. Okay, I understand commercial, but as far as uses, is that really another term for sales for all these other? It's not really use, i.e. smoking it, eating it, actually using it, correct? I mean, in other words,
No,
I'm on
Resolution
attachment 1.
no, it could say commercial businesses, I suppose. I'm trying to find the.
Or activities?
Cultivation, cannabis, commercial cannabis activity.
That's what's in the summary.
So if you wanted to say prohibiting all commercial cannabis activity in the city,
Well,
then
I'm just
that's
trying to get- I'm
tracking
just trying to get-
the state law.
I think we want to have our language tightened down enough so you're not going to be,
The title wouldn't be
well, but
controlling.
it gets into it's also in the whereases too.
But if we change it to commercial cannabis activity, that's defined to be cultivation, possession, manufacture, processing, storing, laboratory
Everything
testing,
would-
labeling, transporting, distribution, sale of medical cannabis or cannabis products.
So where we have uses, we should put activity.
You could say commercial cannabis activities if you want.
All right, I mean, okay, so we should do that all the way, okay,
Uh,
that was my question there. And,
Medical cannabis activities.
and then on the other, on page 2 of attachment 1, that this is consistent with the general plan land use policy. What general land use policy do we have that pertains to medical marijuana? Or is it that we're in conformity to,
I'm going to turn
Federal
that
law?
one over to Tom.
It's,
Well-
it doesn't, it's not against or for our general plan. It's not effective, I mean, it does not affect the general plan in any
Yeah,
way.
it doesn't create inconsistency.
Right.
huh?
It doesn't create an inconsistency with the general plan.
Isn't it just referring to the prohibition of federally prohibited land uses? Isn't that what it's talking about?
Well, I'm just saying, we're putting in here
I think it's just reiterating that it's consistent with that,
that the code amendment to prohibit
right?
is
All right,
consistent with
What page are you on? I'm sorry.
is consistent with the general
Top
plan.
of page 2,
Right, but then it says as it,
attachment 1.
As it
As it
continues
continues.
the prohibition of federally prohibited land uses,
as has been the
as
policy
has
of the
been the
city.
policy of, so,
So it's just saying it's consistent with that.
but do we have that in our general plan, that we do
We have,
conform to federally? I mean, in other words, we're putting stuff in here.
yeah, I'll go get it.
If it's not in here, if it's not in our general plan, that we conform or continue to uphold, I guess, federally prohibited land uses, why would we have that in there? Isn't that something that, I guess I don't know if I'm getting too nitpicky, but this is all the type of stuff that's going to probably be subject to attack by somebody who wants to open a shop or something here in town, and,
Mike's been died.
and if we've got loose language,
But I don't know that it does a search on a PDF document. Not always. Sometimes always good.
Well, I'm just-
next question.
oh, let's just, I mean, just find, you can just find that, I mean,
Yeah, we'll
and
get
then,
that answered for you.
yeah, and then,
Where are our policies?
okay, that's, I've just got a question on item, on number 2. We say the amendments will not adversely affect the public convenience, health, interest, safety, or welfare of the city. Since there are questions as to the health and safety of marijuana which have not been adequately addressed to the satisfaction of the city. I guess I don't know, why is that in there? I mean,
Because you have to make that finding that the amendment won't adversely affect the public convenience, health, safety, or welfare.
would it affect the, is that just the public at large or not the individuals that actually
The public,
rely on it?
I think that's always the public at large,
Always
public
right?
at
I mean,
Okay.
that's,
All right. And then
We're up here.
That's my comment there. And then I had one other, I think, which gets into, I think, our findings on attachment 2. Where on G, the city council, of course, I guess it's up, I guess it's not really us, let them figure, they can decide if they find that commercial marijuana activities, can adversely affect the health, safety, and well-being of the city residents. What, I mean, is that just a statement made because you have to make it, whether there's a basis for it or not? I'm just
yeah,
asking.
yeah. Well, no, it's
And-
not something that you have to make. I think there is evidence out there that shows that these can adversely affect the overuse of marijuana, the things that Wendy's been talking about, the safety by the crimes that have happened.
Okay,
So that's not saying the use.
it's just commercial
Ac-
activities.
It's the commercial activities
Right,
can create
yeah.
problems, not, the council's not making a determination that the use of medical marijuana is necessary.
And we won't be, okay, and so personal cultivation's not going to be allowed as well.
That's a separate part of this ordinance that's specific, and again, that's something for discussion. The Compassionate Use Act and the regulation that followed the Compassionate Use Act allows personal cultivation up to a certain number of plants, and some cities have limited it by, like, you can have 50 square feet, and it has to all be indoors. There have been problems with indoor personal cultivation of electric problems, of people watering and leaking in apartments, just like
Smell.
Smell,
the
yeah.
smell which can offend other people.
That
Maybe it's
becomes a much
okay.
bigger issue.
Maybe it's okay in a single-family residence, maybe it's not okay in a condominium, attached condominium.
Okay.
Right now, the direction we were given by the higher-ups from
That
the
covered
city
all.
attorneys was
All
to,
right. Okay.
was to
Okay.
prohibit everything.
I'm not that familiar with it.
Plus, also
Nor am I.
burglaries and things when people personally cultivate. There are a lot of cities, more in Northern California, that allow cultivation, but those are your more wide-open cities.
Right.
Right.
Where they've got land, not
Mhm.
urban-type cities,
Right.
where we're all on top of each other.
I'm good with it. I mean, with the idea that it can all be revisited and.
I think, Art, we could just change that this is not inconsistent with the general plan on that resolution.
Not that'd probably be better, it's not inconsistent, I think. You're the one who gets to
Well,
deal with the
this-
challenges and
this-
stuff, right?
The planning commission's resolution going up to the city council doesn't come into anything, it's just your transmittal document.
Okay.
So we just say is consistent with the general plan. And then we can just take out the rest of that. And then I think that solves your concern there. I understand that throughout the resolution and the ordinance, we're going to change the term medical marijuana uses to medical commercial cannabis activities.
This might be a question for you, again, with regards to cultivation. Right now, there is no ordinance, so you go to a house for some other type of a call or something else, and obviously, you go in and there it is being cultivated. Is that, at this point, an infraction?
No, well, it used to be a felony.
It used to be, right?
It used to be a felony, but those have changed.
And so it isn't, is it even an infraction now, or no,
No, I believe it's a misdemeanor now.
if you're cultivating,
Correct.
and no matter what amount?
We came up with language.
I don't know, no matter what amount, I mean, we don't have any of those super grows in our city that I'm aware of.
Right?
I hope not.
If there are, I hope you're aware of them. Yeah, so, okay, so I was just curious if, how that goes. I mean, if,
We're just going to make it say it's consistent with the general. But-
now, if an ordinance is in play, how does that change the infraction?
An ordinance is typically misdemeanors, so
Okay,
we would cite them and just like you would any other municipal code violation.
okay.
Any other comments, questions, or do I have a motion?
I'll make a motion to adopt Resolution 15-19 as with our couple of changes that we made to the resolution.
I have a motion and a second. All in favor?
Aye.
Opposed? None? Motion carried. Which takes us to item 8B, zoning.
Is that the only one we have to do on that one, right?
Yep.
Yeah, you passed the resolution which forwards the ordinances.
Tom, if you'll send the documents back to me in Word, I'll make the changes tomorrow.
Okay.
Thanks for the information.
Thank you, Mr. Moore.
Yeah, thank you.
Interested in outside dining?
Good.
Non-conforming uses?
Run.
Yeah. So item 8B, outside seating, staff report?
Yes, Chair Riley and Commissioners, this is zoning ordinance amendment 1504, which is administrative permitting of restaurants with outside seating areas. And as you recall, last month, you read over Marietta's guidelines for outside seating and directed staff to basically take that and fit it into our code. And what you have before you tonight is the ordinance that we devised based on that. So it'd be a good time to open it up to the public if there are any left here.
I think we can just go right past that.
Get my other glasses. Nope.
All right, so I'll go ahead and open the public hearing and ask anyone to come forward. And seeing no one come forward, I will close the public hearing and bring it back to the commission. Questions, comments for staff?
Comment. We have, right now, we have 300 square feet is a benchmark. Do we need to have language in there to state that it's 300 total? In other words, they split it up, 150 and 150, is that addressed there? And note it'll be addressed at the counter with the floor plan being provided, but do we want language in there to give you the authority at the counter to make that decision?
Might be useful to have the word total in it,
Yeah.
If you want total, or it could be,
if the commission agrees.
Yeah, I think that's the intent.
right.
Okay. What part of the ordinance were you looking at exactly, Ted?
Page 2 of
Page
the
two.
ordinance, where it says 300.
Oh, okay.
So it'll probably be in several places.
Yeah, we'll have to repeat
Okay.
it. We could do a total footprint or 300 total. We'll clean it up.
Right.
Yeah.
Anything else?
I got questions regarding, on page 4 of the attachment to the ordinance. If this is going to be handled over the counter, I'll say less formally than a CUP or something like that. Are we, it seems to me that there's quite a few burdens under the submittal requirements for a 300 square foot, space, okay? Like, if we want a floor plan showing the, and I guess the question is, can this be a sketch, or is this gonna have to be scaled? Are they gonna have to pay to have a designer
Textual drawing.
come in it? I mean, a floor plan showing the layout of the, okay, this is for exterior, so why do we need to see a layout of the interior space? The proposed outdoor seating with appropriate setbacks indicated. I think that if you give them a list of the requirements, and hopefully it would be 3 feet from here, and you got to have ADA compliance, and we're not going to check it. Somebody else is going to come out and figure out what ADA is. If some guy in a wheelchair can't get through and decides to go to his attorney, you better be compliant, or you're going to find yourself on the receiving end of a problem. Why do we want to get? I mean, I guess why do we want all this? And then a site plan and a vicinity map showing the location of the restaurant within the entire center, the name, business name, street. They're getting a business license, or they already have a business license, so you have all that information to begin with. It just seems that you're, duplicating a lot of the stuff. If we furniture, fixtures, submittal must identify the exact style, color, materials of everything. We give them the requirements of what we want or what they can't have, and I don't know, it just seems to be and then a hold harmless agreement. I kind of understand that a little bit, but do we record it on the property? I mean, this is for a business. And if we're only going to have it go from year to year, what's the purpose of recording it?
We wouldn't record it.
Well, it says recorded. And they're not in the public right-of-way, so why is there a hold harmless agreement, for us, if they're not in the public right-of-way? They're on private property. I would think maybe the owner of the center might want to, that's up to the landlord and the.
I think the concern is that if they're right adjacent to the public right-of-way, and somehow they encroach over into the public right-of-way, and somebody trips, say the chair moves out into the public right-of-way and somebody trips, that now the city's going to get sued because it was an encroachment in the public right-of-way. I don't think that's burdensome. We're not asking for insurance for them, an insurance requirement. There'll just be a form that will be created that they will sign.
All right, okay.
Yeah, we
That
could-
just
right.
makes it clear that, somehow, because remember, you're not requiring barriers if there's no
Alcohol.
alcohol. So table kind of starts moving.
Or the nose of the car goes over the curb stops.
All right.
So, but if
There's
we're
a
not
logic
gonna,
there.
if we're not gonna have them record it, should we change that language?
Yes, I've already crossed that
I
out.
think recording goes too far, you're right.
And then-
And in part, some of these things are, you told us to basically copy the Murrieta code. There were a
Right.
few places where we recognized problems immediately, and we didn't
Put it-
verbatim copy the Murrieta code, but we're not wedded to this. This was,
Well, yeah, yeah. And then on page 5, dining barriers, we just mentioned we're not going to have them, but we have it in here that they're recommended. Recommended morphs into required pretty quickly. I mean,
I think it's,
why don't we just leave it out and just barriers are required if alcohol will be served in an outdoor seating area, just leave it at that. And if somebody comes in and if they want to put a barrier up, I mean, it's fine. If they don't, it's fine too. What do
we could just say barriers,
Still want the design and appearance part where
yes.
Steve can approve
yeah.
what they're putting up. I
For
think we want
sure.
to keep that in.
No, he's just talking about the barrier.
He's just, I think he's saying take out barriers or recommended,
Yeah.
thank you.
Barriers are only required,
Yeah,
I think is what.
yeah.
Yeah.
And then,
We could say otherwise they're optional, just so
Right. Well,
somebody,
Yeah, I think you need to kind of keep that recommended or optional or something in there, otherwise.
or optional.
You can
You
say,
could put-
Because
Not
if-
say
fine.
optional.
Parentheses,
Yeah,
put
because if,
optional.
Optional
or
is
just,
fine.
just
Yeah.
change recommended to
Because
optional.
if
Yeah.
alcohol's
Yeah.
served, they're coming for a
Uh,
CUP anyways,
Exactly.
right?
Optional. Yeah, I like, that's better. Optional.
no, they're not. The way this ordinance, that was one thing, we talked about this at staff level, that if somebody has an alcohol CUP for the interior, the way the ordinance is currently drafted, they already have an alcohol CUP. We were not going to make them come back for a CUP just for the 300 square foot outside dining, because then this whole process of having an administrative
Spread out.
process just gets swallowed up by now you need a CUP if you move your alcohol outdoors. And the cost goes up. And the cost goes up, and we really haven't accomplished anything. Now, if it's a new restaurant coming in, or they're coming in for a new alcohol CUP, then yes, it will come back before the planning commission. You guys can change that, but I just want you to be aware of how we wound up drafting it after discussing it among ourselves, that it didn't make sense, in our opinion, our
Weren't
humble
we talking
opinion.
about
Okay.
the enclosure also having now to do with parking and, enclosing the area that, with 300
Just
feet,
over
with 300 feet, we're not worried about
Right.
parking.
Right.
No.
Over 300 feet, you're not worried about parking. Over 300 feet is going to require a conditional use permit and will require complete compliance with the outdoor parking, the outdoor dining parking standards, which is 1 per 150. So if they had 400 square feet of outdoor dining, they'd need 3 spaces.
Yeah, round it
All
up.
right.
Yeah.
300, that's no CUP.
Right. No CUP, no additional parking for 300 or under.
Total.
300 total. Well, 300 total per business.
Right.
Not for personal.
No, not per shopping center.
Contiguous business.
Can we go back before I lose track on Art's comments on the site plan and vicinity map? Would that be covered by CUP requirements, Tom?
Well, with the CUP, you have to provide a full,
So then the question is, that will already, we don't have to have it in here for the CUP requirement.
right.
Do we need it, does staff feel we need it for?
If I can't find the business, then I'm in trouble.
Okay, so we can,
Well, yeah, I mean, you're-
Well, yeah,
Right.
I did that for a year.
I agree with Art. We want to make it easier, but if there's a reason that staff thinks they need some of
It's
this stuff,
required,
that's
required
fine.
on
but-
building permit.
sketch, I mean, I would say, just, you know, if you're gonna, if you need something to show what they're, just a sketch.
That's
It's
fine.
not
We-
scaled,
Yeah.
I mean.
we could say
graph
for
paper.
floor
We-
plan,
Graph
we
paper.
could say a diagram showing the
Well, and keep in
layout.
mind, Art, that some of this stuff
And take
isn't,
out the word.
isn't that difficult, like a site plan, a vicinity map. I mean, you could pull something off of Google Maps
but-
pretty easy and.
But staff's saying they
print it
don't
out.
even need that for the,
Yeah,
Yeah. For the
over the
CUP,
counter.
we do because of the
but it's,
fact that it
but
goes
it's
to the
in the
building
CUP
department.
requirement.
sure. And I'm fine with that as long as staff has what they need and we're sticking to the intent of this, which is to,
The vicinity map is to show you where it's located in the city. If I can't find where Nick's
They
is,
can't
Right.
figure out where it is.
The city just isn't that big.
we're 2 miles
We're not-
across. It is something that's on all building plans.
Yeah, on building plans, because it goes to the county assessor, and the county assessor has to know where to go.
I'm with,
They don't know the city.
I'm with you, Art. I kind of feel that the furniture and fixture, that piece underneath 3,
Yeah,
That
and
says
somehow
that
the
this-
numbering got messed up.
Well,
and I'll
just-
have to fix that.
well, not that part, but it says, you know, how you have, the submittal has to identify exact color and style and all that stuff. I mean, if you go to the furniture and fixtures section,
You tell them, but
it's very descriptive on what it has to be. So do they, are you guys going to be inspecting after they come in for this and they set everything up? Does anybody go out and take a look at it after it's all complete?
Yeah, we do that for every CUP and every approval we do after it's implemented. We make sure it meets the conditions.
So I don't know, I just don't know that it,
The only thing is, in case they don't go all the way go over to reading that part, you'd hate for them to buy everything and go, oh,
well, yeah, so I
I didn't
understand that part,
know.
but
come on, they gotta be.
But it could be kind of onerous to identify the exact style, color, and materials of all fixtures.
I mean, you give them a list, and you say, look, read this, because this is what you can't have. This is what it has to be, and here's what you can't have. We're not looking for fluorescent, we're not looking.
Well, but
You know.
staff will want to know
Yeah.
ahead of time, right? So
well, I
they're
like
coming
your
in for
point.
approval.
I like your point that they don't go, they didn't get that far and that is true. They go buy everything and then all of a sudden it's the wrong stuff.
I didn't know I couldn't have white plastic resin chairs that they sell at every.
That's exactly it. So staff needs to know before they can approve,
That's-
they need to know, okay, what are you going to put out?
But
there?
in all honesty, do they even get this far? I mean, the person who's not going this far, do they even get this far?
Well, this
So
they have
then-
to do at the counter.
That's what I'm saying. So
Yeah.
then at what point do you kind of give them that furniture and fixture, say, hey, make sure you do
We turn
this?
this into a brochure much like Marietta did.
Okay, okay.
That's-
Oh,
You're interested in this? Here you go.
okay.
Read, yeah, circle this.
I mean, I don't think it's an issue. Just
Highlight.
it gets,
Circle.
it gets-
Whatever the planning commission's desire is.
Yeah.
I understand the intent of that, and I think
And we
it's
could
important to have
take
that
out the word
information when they come in
exact.
to ask for their permit.
yeah.
I think the word exact kind of is a challenge for me
Screw it off.
because, but otherwise, I
Yeah.
get it.
So take the whole thing out or take the word exact?
No, I think
Well,
just,
you just take
I think just
exact out.
exact. I think it reads better. Yeah, I think
Yeah.
that's fine.
Don't scare them away.
Okay, so far, the floor plan will now say a diagram showing the layout of the indoor business space to take the plan.
Why do they
Because
need
that-
the indoor? I'm curious. Why would that? be-
Because you want to make sure they can walk in and out of
All
whatever
right, okay.
doorway
I
area.
think the business people are.
So often art, they already have a floor plan. They're just
So it's-
sketching outside
All right,
and
okay.
I mean, it's-
putting it on
Cool,
a
just
copier.
sketch is
It's
fine.
essentially like that.
Yeah,
I mean, really.
right,
Yeah.
right, okay.
Going back to the vicinity
If
map,
we could use it.
No,
in-
we took out, I'm
is
sorry.
that gonna be relevant for ABC to know where to go?
ABC?
That would have, for
That's a
for
separate-
alcohol, that would
separate
go through a
application
CUP and
That's
ABC,
separate.
so
We're not
that's.
gonna do, we're not gonna do that.
But ABC has their own application process for someone to apply for an alcohol permit with them.
I don't think that they have to get another permit if they move to outside dining.
I don't think so.
No.
Not if they have one for inside and it's enclosed,
Right.
then it
So-
extends out.
So, I know, we're not doing that.
No, what we're saying
But
is they want
ABC
to
already
serve.
knows where they are because they already have a license. We're just letting them use 300 square feet outside.
Right.
And if they want alcohol out there, they have to have it enclosed.
Right.
That's it. And we're not asking them to come to us for permission. We're having them go to him. second hint.
All right, so where are we at now?
We're trying to make it customer friendly, which is a good exercise.
Art, did you have other comments? Or I should be marking?
What page are you on?
On page 8 of 12.
Okay.
Is there a reason, I mean, under H, I understand it says, given the constrained space, square or rectangular is
I-
better than round or octagonal?
I don't think we care. I think that
There we
was
go.
another copy,
Yeah.
page
So H.
8.
Yeah.
H.
And then,
Square or rectangle, that's funny.
even I, do we really, I mean, we've said that the umbrella up in G, we've said umbrella fabric must be one solid color and not permitted to be a fluorescent or other striking color, and we've already eliminated the, advertisements on it and writing on it. So umbrellas designed for patio and outdoor, are preferred, okay.
That's more about quality.
Yeah, yeah.
And this is recommended, it's not mandatory.
All right, okay, good. And,
So we're taking out H? Was that the
Well,
consensus?
It
No,
says
I'm not sure
recommended,
Oh, okay,
it's on that.
okay.
and then on
I-
prohibited sidewalk coverings, number 4, why go through all of that? Why don't we just say, there should be no covering, what you have out there is what you have. You can't cover the outdoor dining space.
I think,
Just none. There's none allowed. There's no,
Well,
right?
no,
that
but you
was
have
the
some
one that
that
was
that might
designed
be,
to say we couldn't.
they
put
may
in.
want to have that. We want it to be nice in appearance, durable, hold up, we don't want
No,
to
but
be
we-
that.
Prohibited side, the floor of the
I was just
outdoor
gonna say
should
what
be
it was for.
uncovered. That's
Mhm.
right, continuity, prohibited scenery coverings. And then you go ahead and list all the stuff that are prohibited, as if, first you say, the area should be uncovered to provide continuity, and then you go on in the next sentence and say, prohibited seating area coverings include, well, if you've
Everything.
said that you don't want anything, then you're saying these are prohibited, then the next question is, well, then what's allowed? I mean, it seems like it's
Redundant.
It doesn't say
it's
AstroTurf.
contradictory. It's kind of like our president.
Fake grass.
Yeah, they might plant some grass, throw some dirt down,
It
put some
says
seed down.
linoleum, nylon, vinyl, or any covering intended to resemble turf.
Just, we don't want any. We don't want any
You
sidewalk.
could probably
coverage.
just stick with that first
The
sentence
first sentence.
and get rid of the rest.
There you go.
Where
So
they
is
got
that
it.
the direction from the commission?
Mm-hmm.
Okay.
Oh, and then
But
under,
this also says should be uncovered. Are we gonna require it to be uncovered? Because if you take that sentence,
If you take the rest out,
which
then
is I'm fine with,
Then should
Yeah.
is becomes
make
recommended.
it
then
shall.
should, yeah.
Shall. And then on 9 of 12, we're kind of back to administrative permits, and now we get into B, the bottom on 9 of 12. The application shall be accompanied by detailed and fully dimensioned site plans, architectural drawings, scaling, elevations, floor plans. That's everything.
Where is he?
That needs to be gone.
Page 9.
Oh, page 9.
12,
I think,
Strike that whole thing.
right?
Mhm.
That's under administrative permits.
can we modify that to say unless otherwise required for the specific?
Well, for CUP, it's
Permit.
different.
No, but the idea was this AUP would be used for other permits as well
In the future.
in the future.
Should you decide you want other things administratively approved, this covers that. Right now, the only thing that we have in our city that's administratively approved is this new outside dining thing. So in order to have an administrative use section, we have to adopt one. So this covers anything in the future you may ever want to have.
So are you gonna say, is there gonna be a B1, outdoor dining shall provide this?
I think we can just say unless otherwise specified elsewhere in this code.
And then that would be specified under
Well-
outdoor dining.
Yeah, where you already put those requirements?
Yeah.
All right, okay, all right. I mean, it's, just so it doesn't get confusing, or, well, I don't know.
We don't want people to try to guess, well, do I have to abide by this or this? You want to make it somewhat clear.
All right, okay.
If you use a lot of footnotes, Steve, in your code, you could footnote the outside dining section if you wanted.
That's a good
And
idea.
then it'd be really clear.
Yeah.
And then,
What I missed
The city's code, our code.
It's actually Development Services Director now.
I only got 2 minutes.
Sorry, what
That's okay.
page?
All, anywhere. Just do a word search.
Community Development Director's Development Services.
I'm 10 of 12, under action by Community Development Director. A, the Community Development Director will process in accordance with standards set forth herein, and may impose reasonable conditions of approval. What would be an example of reasonable conditions of approval? I mean, if they've all,
If you change your umbrellas to this, to meet the code. Okay, I approve it, I stamp it, but change your umbrellas. Stuff like that.
Yeah.
Or remove the turf.
well, they couldn't put it in to begin with.
Well, exactly, but I don't want to have to redo their drawing, right? So you just put a condition on it
All right,
saying,
okay.
remove the turf, approved,
All right.
excluding turf.
That makes sense.
It's one of those things where you
Yeah.
try to be amenable at the counter.
Yeah, okay, all right, and then,
Development Services.
Yeah.
on the expiration of permits, should we just, I like the idea that it automatically expires 1 year from the date. And then, rather than have them apply for a renewal, can we have it that it's just automatically renewed unless there's a record of complaints or, any type of complaints or written, if there's been some issues that occurred in the year that you
What?
want to review it.
Yeah, I think that kind of opens up the city of, well, you didn't do anything, so.
Or it rides with the land. I think
Yeah.
Lisa wanted to separate it from a
Well-
conditional use permit in that they don't want to think that this is an entitlement that runs.
So it's a simple renewal, nothing, they don't have to resubmit.
What have you changed?
Fine.
We do that with special event permits too. People say,
So-
like the Christmas tree lot, oh, bring your permit in from last year. Just update your insurance.
And is there a renewal fee? I mean, do they have to pay for the permit again, for the annual permit?
We haven't put that in here.
If the
Is there an annual
council,
fee? Is there a renewal fee?
I would.
We put a fee in here, but we
In
didn't. put-
resolution, I put, that we need to make it like the SEP fee.
Right, but we didn't put a renewal.
The renewal part is
Right,
the one I'm
right.
asking about.
That's
Do
up
you-
to the commission. What do you?
Council.
Well, yeah,
Mention
council
what is
will,
your cost of
but do you
service?
want to provide a recommendation?
Are you gonna go out and re-inspect it on a renewal? How much time are you gonna put into it? Is it worth even collecting a fee?
I mean, that's, if,
What would be an average
Tough.
fee from another city, do you know?
Oh, some cities are thousands of dollars, even for administrative use permits.
For a renewal? Would it be like
Yeah.
$25, $50?
I mean, if we're leaning towards a $75 for the original fee, so you wouldn't want to exceed that,
No.
and probably not even match that. It'd probably be something lesser than. But the
Renewal at
city council will have
$25.
to adopt the fee.
Nothing to do?
It'd be good to have
The
a
council will decide.
recommendation.
Well, I would probably recommend either $25 or $50. I don't know, what do you guys think?
It's really just paperwork and maybe,
Yeah.
I would think like $25.
$25.
If the original application fee is going to be 75, I would think, 25 for a renewal.
Okay. Would you like that in your resolution,
Yes, please.
to recommend that kind of fee? Okay. So when we transfer it to city council, they'll see that your recommendation was a lower than $75 fee for the.
So, that being said, is it something on the renewal, like a business license, would it be something that they just receive an invoice or a bill for when their annual is coming up and saying, you know, or do they have to answer any questions? Have they changed anything?
I think we'll
and-
do a little more hand-holding. We'll probably hand-deliver it.
The bill?
Their application, the application, or their old drawing, and say, hey, any changes? Here's the fee.
Most probably aren't gonna remember that they need to come in to renew the
right.
permit. I guess that's what I'm saying.
That's
So-
what I'm trying to.
So that's what I'm asking. On the renewal or the annual, are we proactive on that, and do we go?
We would have to be. There's going to be some hand-holding.
Okay.
They're too busy running a restaurant.
Well, whether they get it in the
Restaurateurs are
mail,
exhausted.
yeah, whether they get it in the mail or whether somebody delivers it, as long as they're notified.
Yeah.
And we can add to the expiration, city shall give notice 30 days prior to
I
expiration.
think that would,
Yeah.
I mean, for me, I
If
think
that
that would be
Yeah.
the way to go.
Yeah.
All right, anything else on this item?
No.
And do I have
Nice job.
I'll make
a
a motion.
motion?
I'll make a motion with the corrections.
I'll second.
I have a motion and a second. All in favor?
Aye.
Opposed? None? Motion carried.
We are moving so much faster than I expected to. So exciting.
On to item
I know, right?
8C, our continued discussion of non-conforming use provision.
Remember where we live.
Staff report?
Miss Lisa Kranitz is, as she's laughing at me, is going to start
Surprise.
you in this continued discussion about non-conforming uses, parcels, lots, structures, and see where we end up. With that, this is a continued public hearing, so you don't have to reopen the public hearing.
I think, we're still, first, does anybody have any questions about non-conforming uses and structures? I think we've kind of gone through most of the Tustin report. That was an excellent report about non-conforming uses. Attachment 2 in your staff report, we tried to point out for you what was becoming non-conforming based on the general plan. This does not identify every non-conforming use in the city. No way could we do that. But this identifies the areas that we just created as being non-conforming uses for the uses based on the general plan amendment. And those were where we changed industrial uses to multifamily residential, office uses to retail uses, and then when we created a specific general plan area for recreational uses in the industrial, the light industrial, that meant all the other recreational uses in the industrial become non-conforming.
Legal non-conforming.
Yeah, and when I'm talking non-conforming, I'm saying legal non-conforming in the context of this whole discussion. So I think some of the base questions that we had set forth in the staff report the last time are really what we're looking for direction on to draft something and bring it back to you. What types of amortization periods do you want? Do you want non-conforming uses to ever expire? If we have an amortization period, can we please make it something that makes more sense than this type 1 versus type 2 versus type 5 buildings that really most people don't know it's on the building plans as what type of building you have. But I couldn't tell you what my own home
actually classified under.
Nice.
What about a non-conforming use of land that only has an accessory structure? The code gives us 2 years there. Non-conforming uses of conforming structures, non-conforming uses of non-conforming structures. The big issue that came up with the CrossFit is should a non-conforming use in a structure be allowed to expand within that structure if it only occupies one tenant space? Maintaining a non-conforming use requiring a CUP. What about structural alterations? That question got triggered, as I told you, by the Laverne lawsuit, where they argued just changing a loading dock and tenant improvements and a facelift, but not adding one additional foot of a conforming use should have required a CUP, and our code reads the same way. And really, I think at this point, kind of a discussion among the Planning Commission of what you think is appropriate and where we should go. And you don't, one thing I want to specify is, as we talked about during the general plan process, you don't have to treat them all the same. I mean, we could talk about non-conforming uses in general throughout town, but have something different for these new non-conforming areas that we created in the general plan. It doesn't have to be the same as long as we're treating everything in like the same zoning district or in the same type of category if we can categorize it the same. But you can't say CrossFit recoil, you got to go, and batting cages, you get 20 years. Or vice versa.
How does that actually work? If that amortization period comes up and say it's 10 years, 10 years comes, and they're still there?
Well,
Does the sheriff show up there and like boot them
No.
out, or do they?
no, technically under code, then we're supposed to give, somewhere we were supposed to have given them 2 years' notice. But let's say we've given the notice and the time is up and they're still there, and we say, go away. And they say, no. Then we could go to court and bring a civil action and make them go away. And that's a lot of money to get to that point, and whether the city would want to undertake that or not, I don't know. I mean, some cities have.
Sure. So there's two things there. One is, what are we going to actually do when those amortization periods actually hit? And the other is, what does just having an amortization period say to the people operating those businesses, right? I think it says, hey, you're here, you weren't really supposed to be here, and we'd like you to move somewhere else, hopefully within the city, right? And I think part of the general plan was to create areas for some of the, especially some of these fitness and recreational uses. Right, so I think if we've done that adequately, which I'm hoping we did, although I wonder
You
if
have
the zone ends up.
a lot of uses,
I know.
recreational
Well,
uses that are
yeah.
now non-conforming, legal
Yeah,
non-conforming.
I've really thought, I've thought about this quite a bit. Kind of like what you just said. You know, you should have been here or be here. No, they were approved at one time. All of these were at one time approved uses by another commission who sat before us. And those people, you know, when they were, you know, had a lot of hair and were young and got all their money together and they invested in a building or whatever, started their business or rented it out or did whatever, obeyed all the rules, and then 20 years later, another group sits up here and says, we would like to do this or that. And so we're going to change this zone, or we're going to do, and all of a sudden, they become non-conforming. Not that they had,
Well,
and
But
now
that's
we.
not true of all these uses. Some of these
Well, a lot
businesses
of- a
opened
lot-
up and operated and were.
Well,
did it
if they were, no, a non-conforming, if I understand a non-conforming, legal non-conforming use.
Legal non-conforming.
They were legal at one point, before a change
Right.
enacted by the city dumped them gave them now this status, and then on top of that, we then hit them with this, and we want you out in 30 years or 20 years. Thank you, goodbye, because we think that this should be this zone. Well, then we have it 10 years later, before the 20's up, we have a new general plan update, and we do this change, which now makes their, makes what was previously now non-conforming, maybe back to conforming, or some guy gets switched 2 or 3, it's as the wind blows in the city, okay? Even though the wind blows every 10 or 20 years.
Well,
and I understand we're trying to project out into the future, but I think the amortizations are, in my opinion, inherently unfair, okay? If you take the long view, okay, and the long view is that this city will live forever, okay? Outlive all of us. And things will attrit out. The buildings will wear out. Eventually, the uses will change, and and a structure is not, where it says here, non-conforming structure, a structure that does not comply with the development standards, such as a building that doesn't have sufficient parking or setbacks. Well, okay, the setbacks, the parking not so much, because parking is determined by use, I think, not by the building itself, right? I mean, if you have the right use, parking could be adequate. Stuff, there are some things that change, but I just think it's inherently wrong to basically, it's a taking of the property by changing your zone. And like what we do here, okay, that the only concern these guys have next to us by changing the zone is the amortization. They can work within, if we leave them alone, this will eventually, if we decide that this area eventually is going to be retail, where we sit and over there, we want a retail use. It's when these existing uses ultimately go away. When that thing burns down, or we have an earthquake, or it just, in 100 years, in 75 years it wears out, or all of a sudden a developer comes in and gets, hey, it's worth it to try to buy this property and do this retail that this city wanted 20 years ago. But you leave these guys, you leave them alone until it happens. I mean, who are we to, or just think of your own house. I mean, that's the easier way to do it. I mean, all of a sudden we decide where you're located would make a great extension of that.
You start looking like.
We need another hamburger stand right where your house is,
Perfect.
Okay, so to pollute the other neighbors, okay, and all of a sudden you fall under a 30-year amortization, but it started when your house was built. That's where a code right starts. So you got 10 years and you're out. Well, that's not fair. I mean, how much money do you get for your house? Nothing. I mean, it's whatever you can sell it for in 10 years, keeping in mind it's now a property now instead of a residence. I mean, it's
It
not
almost
right.
smells
It's
like
not-
eminent domain.
Well, it is. It smacks of it, but in my opinion, and that's the one thing about planning. I mean, and I went through this in college, and it was great. I mean, to actually see long-range planning. I can remember going through, looking at Desert, where Del Webb is building the first Sun City out there,
Right.
and the big round hospital. And here, it was just sketches on a map, and we're out here driving around the desert, this college class. And now I go back there, and there it all is. And I remember seeing that. Golly, I wish I would have bought the land across the street. Okay, because of what I knew then, and it happened 15 years later. But we don't have that luxury here. We're not in Irvine. We don't have the clean slate. And we have developed the way we've developed, and it will, it'll continue. I don't think we need to try to force people out or put people in these situations where they can't get financing. Not that we would even put them out, but we put them in a position where they can't get financing, on their buildings.
This more has to do with the business, not the building itself, right? It's the business
It
that's
has to do
being...
with everything.
It has to do with everything.
You're talking about lots, structured uses.
Yeah.
So what happens in a non,
I think right now what Art is primarily focused
Is on
is
amortization.
uses.
Yeah, well, yeah.
Amortizing out the use.
Yes.
And I think there have to be separate discussions between what happens when the building
that's what I was
is-
asking, yeah, because,
is
so, because
the
if a,
wrong type of building.
right. But if a business becomes non-conforming, which some of these are now, right? That are up on it?
Yep.
I didn't get that attachment somehow, but
Legal non.
legal, that's
So
what
that
I'm saying,
means
legal
they've got
non-conforming.
a
So
CP or-
if that business tries to sell now, not the I'm not talking about the property,
Right.
whatever, just take one of those, whatever business that is, they try to sell it to somebody else, can that person actually buy that business? Or is it because it changes ownership now, does it become,
No, I don't, the change in ownership, if you're not expanding the use,
doesn't have any effect on it?
no. that would-
Except for if it's amortized, then that new owner needs to know that he may only be able to have it for
He needs to do his due diligence.
5 more years or
Right.
10 more years or what have you.
Exactly.
And the big guys will do that. They'll call us and they'll read through our amortization schedule, and they'll read through our non-conforming section. Their head explodes and they call me 9 times. As you guys know how confusing it is.
But that's different for
The big
use
guys do
versus
it.
land,
The
right?
small guys don't do it.
So
But
that's
that-
interesting. So that water safe swim school,
Mm-hmm.
say there was a 30-year amortization period. I don't know what it is on that land, but we give them a CUP and they make this substantial investment to build there with the expectation that they should only be there for 30 years or whatever the amortization period is.
The ordinance doesn't specify it, and it will on the rewrite, that there has to be a hearing procedure for them to come in and appeal, like if we were to issue amortization notices, that they come in and appeal and say, I haven't received the full benefit, and it's a hardship because, I haven't recouped my investment. And there is more legal language that goes with that,
I
but
think
at
we
this
have
point.
to, I think we have to think beyond that, To me, the narrow view to take is, well, we've changed the zone, and that means we want these people out because we want to have this new zone go into
But it's
effect.
not even
And these-
changing, it's not even changing the zone. Like the water safe swim school, for instance, it's us saying, say the amortization's 30 years, it's us saying, we're okay having you here for 30 years, but 30 years in one day, we want you out.
Well, that's what we're
There's an irony about that, right? There's
Yeah,
something-
and
that seems a little
that's,
strange.
that's the inequity of it. And my opinion is that, of course, I guess maybe it's the market. If there is a market for that business will survive. And it almost seems that if it gets to the end of the amortization period, if there still is a market for that business,
It'll stay.
who are we to throw them out in favor of another bit? And in other words, the whole, you get the changes. If the zone is changed to retail, just taking this site here where we're saying, or Arrowhead even, okay, would be to me even the better one. If the zone is, you leave them there indefinitely, you don't amortize them out. They've been here for 50 years, they can be here for another 50 years. For what reason? And only one reason, that aerospace continues. That they provide a viable product to the government or whoever they deal with, and that site works for them, they will be there. The day that ceases and the day they decide to sell the land, that's when we want it to go into a retail use.
Well,
But
sell the land for a different use.
exactly, when they,
In other words, no schedule. No,
in other words,
we're not forcing it.
We don't force them
Type of
out.
business stays.
They stay under their own,
Because
and
it's demanded. And
Well, I think that property in particular, we struggle with that, right?
we did, but if we take and that's the thing, we take the real long view on it, eventually, it will change. It may not be in our lifetime, but the zone is there for when it does change to, let's say, become retail. Okay, but we overlaid it, so that's maybe not the right thing. This is probably the better one, because we did change this zone. And this will be retail at some time in the future unless another planning commission in another general plan update decides that this should be something other than retail, maybe go residential, or something like that, in which case, the poor retail guy who came in, in the next 2 years, 10 years could be out under an amortization. I mean, it's all because the city makes these changes under the visionary guise of we want to try to look into the future to try to do what's best for the city, which is great. But I think we just have to keep in mind that it's taking a long view. It's in the long run, and if it happens sooner, great, but we shouldn't be forcing the issue. I mean, and 30 years is a short time.
Well, and here's the thing. I don't make these decisions for the city, but I don't think this city is the kind of city that is going to force that. If the amortization period expires, I don't know that we're going to pursue.
Well, but if we have it in the books,
and
we
try
have to,
So then-
anybody
so-
doing that has to assume.
So then why have it?
So then why have it?
Well, that's kind of the point.
Yes.
That
I'm
was
just
the
saying- I'm
original
just-
point I was starting to
if
make.
it's not
is
gonna be
why have
enforced.
these
Why have
amortization
them? Yes,
periods
exactly.
if it's unlikely that the city would enforce them
Right.
and kick people out? And because what we really seem to do in this city is exactly what you're saying, right? We're not strong arming people.
Right.
We may be, hey, you can't expand your use, you're not going to get a new building permit because you're out of compliance or whatever, but we're not saying you got to be out and we're going to get the lawyers and we're going to come after you, right?
I will play devil's advocate for just a second. There is one case where you may wish to have it, and that's the case of the industrial properties on Sausalito. You have the Olson project, right? And then you have an industrial building, which is a church, and then you have an industrial property, which is a backhoe company. If the church gets developed as residential, then you have that residential next to an industrial use. If the industrial use takes years to transfer, you're going to have two very incompatible uses. Residential and industrial together are the most incompatible of the uses. They're the most contrary to each other. But that is a rare case in LaSalle. That really is a rare case. And I don't know if you designed a code for the rare case, but you have to know there will be times where the uses next to each other will not be compatible, and you may have wished to have an amortization schedule on like the Monte Collins site.
Is that property active? I mean, is he operating? there?
It's active, but no, yeah, Monty's operating his business there, yeah. Yeah, he's fully operating his business.
There's another way to look at this also. These amortization periods should be designed for the health, safety, and welfare of the communities, of the people, and they have to be reasonable. So maybe we want to structure something it's reasonable. In other words, don't have an amortization period for the heavy industry or the light industry, but in a residential zone, establish an amortization period, because you may have a use in there, like Stephen says, where it does impact the health, safety, and welfare of the R1 zone. So you might want to have amortization there, whereas in an industrial zone, there's not going to be that concern. There might be, because you have pedestrians where there's no sidewalks and so forth. But maybe we want to have a strict across-the-board period. We want to have it fluctuate by.
And that's what I was trying to
Does-
say.
so is
And
it-
the other thing I'm sorry, to point out is, in that industrial to multifamily, looks like there's several parcels back there. Let's say the church wanted to go away.
That's been changed to residential.
And it's now multifamily residential, but he can't find a buyer because he can't say that industrial property is going to be gone in 10 years or 20 years. That industrial property could stay forever, which then creates a problem for the neighboring property owner.
Has that property also been changed? So that whole piece?
Do you have attachment 2 in your,
No, my attachment 2 was the attorney's letter.
If we change the zone.
I don't know what happened. Thank
change
you.
that- for using the church as the example, which is a industrial zone, but it's a church use in the industrial zone, okay? And we did change the zone to residential, okay? So if that church decides to go out, okay, then in order for that use to be, quote, grandfathered in and continue, it would have to be to another church,
Exactly.
correct? So all the talk about an incompatible, and a church is, I think,
But-
by definition, compatible in a residential
Right,
area.
but let's say
Well,
they
but-
just say, we want to sell the property. We'd like to, and the highest and best use that we can get is multifamily residential, but we can't because there's this
Yeah, I
industrial.
think it's the adjacent property that's the concern, right? So
Like
there's a
Monte
couple,
Carlos.
there's a couple different things
All right.
I think we're talking about.
Yeah.
We've created some,
We're just trying to put scenarios.
yeah, but we've created some non-conforming uses with zone changes in the general plan update. And then there are non-conforming uses because they're CUPs and they're in the wrong zone because of action that was taken by the planning commission. So do those all have to be treated the same?
No.
Or can we say, hey,
No.
if you've got a CUP, you can stay in, you don't have a amortization period, but if you're, I don't know, is there a way?
But
to
Can you
why-
grandfather in all the CUPs?
But,
Well, because we've given them permission. it
okay,
seems.
but if you were allowed by right, you had permission. And then you changed the zone. Why is the fact that you got a CUP better permission than I was specifically allowed this?
And then don't
By right.
CUPs can go with the land? so
CUPs
now
run with
it-
the land as long as if you don't have an amortization period, then the CUP,
Proposed,
Well,
as
does-
long as there's that same use. But-
Right.
But even in the case of Monty Collins over there, then we changed his zone to what, resident, we changed it all to residential, correct?
is Monty Collins in the brown?
Okay, even if he refuses to sell, let's say
thought it was.
a housing developer wants to come in there and just do it all, and for whatever reason he wants to be the holdout and say no, then the houses get built, and yes, a few of them will back up to the industrial, but now our codes kick in with respect to noise and dust and all of that. And isn't it more stringent when you're closer to a residential area? I know we went through that noise and all of that.
They'd be coming to a nuisance, so there would probably be,
There's also AQMD stuff at that point.
So then it becomes, they either can't continue their business in the manner that they've been operating, or if they try to sell it to somebody else in a similar business, they come in and they see all these regulations, it's going to be, diminish the value of their property to the point where it'll probably.
but normally you'd
Yeah, but-
require disclosure.
I'm just saying that the problem, I think, the market will resolve it, it will resolve the problem in time without us forcing it. And houses that back up to those will sell for less than the houses that don't.
Well, but to
And-
Steve's
and-
point, maybe those houses never get developed because the developer's not willing to buy that, knowing that that's his neighbor.
Well, they either will or they won't. I mean, and it's all a function of, can you make enough money if the price is low enough, they'll do it, and it'll get built, and I.
Now, based on the previous conversation, he sells the business to somebody and it can stay there. But if he sells the land, whoever's buying that land cannot put an industrial, they won't be able to get a permit, will they, for an industrial use in that property, correct?
Well, the use may not stop. Just
The use
because
may
of
go
the
on.
buyer.
No, I'm saying, let's say that the business closes.
Okay.
Let's say that this new owner comes in to buy the property, but he's not gonna
But
buy
is
the
he going to put
business.
another industrial business there?
My question is, can he,
Yes.
based
If it's not more intense, then
but it's
yes.
zoned residential, isn't it?
But the use
Grandfather, the use,
the use is grandfathered, it hasn't expired. If the person was actively marketing his industrial property, then if you don't have an amortization period, then I think.
Why can't the
use-
amortization period be when the property's sold? I mean,
well.
in other words, when the property sells, it automatically becomes residential and you can't have an industrial use if the person's not buying the business. If he's buying, again, there's a use and then there's the property.
Well,
I think
no,
Yeah, but that creates issues.
It will
What
if
if
the
you have a
use
business
ends.
on a property, but you don't own the property, and they sell the property? And now, oh my God, I just did this swim safe school here, and I didn't own the land. I was
That's
on a
in
30-year
the,
lease.
that's in the lease, is it not?
Well, I don't know. I don't know.
I mean,
if
I don't
in
think that's
every
on
lease.
us. I think that's in the lease at that point, with the guy sells the property, it's now residential. and-
Normally, the way the amortization codes are, assuming there is no amortization period, or you're within the amortization period, as long as the use is not a more intense type industrial use, it doesn't intensify, then another industrial use is generally allowed to go in. Doing it by when you sell the land could raise different equity issues. It's not, it's kind of a case-by-case basis. in
But
the
it
sense.
raises equity issues with amortization schedule too,
Well, but
because,
if you applied to everybody the same, everybody in the same situation the same. Like if you'd say, okay, everybody in industrial to multifamily residential area, that's a 20-year amortization period or a 30-year amortization period from X date, then it applies to everybody the same.
well, it applies to everybody the same if it's, when it sells, it's just the date changes as far as when that property sells.
But you may have different, you may not be recouping your
Right.
investment. I don't know, I've never seen one like that, I'd have to give that some.
So what about, you mentioned the whole
Everybody's thinking outside.
CUP
It's 'cause everybody's playing
being
with it.
treated differently than a zone change where someone had it by right. That person in the zone change would
Well, why
have
are,
the option to come in and get a CUP.
In our code today, yeah, you're right.
Right,
You
and
can
then,
come
and then
in
they,
and
so they have the same opportunity to
No.
make the same case and get a CUP.
There
I
are
mean,
some
otherwise,
cases-
otherwise they could come in and say that the whole zone
Let's-
changed, that
let's not-
amortization period.
But there's some cases on a CUP you couldn't make the proper findings. In the Monty Collins
Right.
one, you probably couldn't make the findings. Other ones, yeah, you probably could easily.
I think the discussion should not be what does our current code provide, but what do you want to have it provide? Because our current code is point blank a disaster. It's very difficult to understand. I mean, when the whole CrossFit came up, Steve and I, went through it for a long time. What does the code really mean? City attorney and I have gone through on various non-conforming, what does it really mean? When the people in our positions can't understand the code, I'm a strong believer code should be written so that anybody can open it up
be nice.
of a reasonable intelligence and understand what the
Appraisers,
code says.
lenders, buyers, owners, commissioners should be able to understand your intent. If your intent was that uses should disappear when they're not compatible with their neighbor, there's a way to say that. If it's commercial uses, residential uses, these are the things that you will vet and then provide us direction. We have, but you're not there yet. You're still talking about and understanding it and how it applies to our city. This is a very valuable discussion to understand these real-life situations on land that you guys pass by every day.
Why don't we have our discussion, why don't we segment it and talk first about non-conforming parcels and just focus on parcels, and then move to uses, and then to structures and things like that, because right now, we're kind of jumping.
I thought we've
From-
kind of been focusing just on the uses. That
Okay,
was
so
my
let's do
understanding.
uses and not worry about buildings and parcels and things of that nature.
Okay.
I think there's some questions we can ask the commission. If somebody's zone was changed, do you want their use to cease when they run their course? If they're vacated, like next door, office is vacated. Here's an example. Do you want an office to be able to open up next door? If you owned it, you probably would.
But that wasn't the intent when we did the general plan, we
No,
wanted it to be retail.
The general plan was that you wanted office on the second, office to probably cease.
Right.
So an amortization schedule is the way to do that.
Again, can we fashion amortization schedules by zone? R1
Yes,
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 is quicker than
you have
industrial.
to.
absolutely.
You have to treat them fairly.
That's the way we should do it.
So a residential use, a residential building or a residential use in an industrial zone, you probably want to disappear because you know that's not compatible.
No, I would do it the other way, because I would go for the
Industrial
higher
use.
use. The higher use, if you have a non-conforming use in a residential, an R1, I would want that to have a shorter amortization period than a residential use in a heavy industry, because that use would self-correct, like Art says.
Yeah, good one.
But for the safety, health, and welfare of the citizens, you wouldn't want a non-conforming use in an R1.
Right.
That
We
makes
give
sense
some
to me.
other examples of non-conforming uses that really are kind of compatible. The house on the corner of Catella and Lexington. It's zoned commercial office. It's a house. Non-conforming, who's a bother?
My wife.
Because they've been
Every
lack of
time I
maintenance.
drive by it, we'd go, the city should buy that, just make a park, it's terrible. And actually, I was on the sewer, they were on a septic system up until recently, probably in the last 10 years, 10 or 15 years. They were the last parcel in the city to go hook up to us, to the main sewer. That was on they had a septic tank back there.
So there's a use that's really, does it matter to you that it's not an office right now? Or it's
No.
not a commercial shopping center?
No.
Because it's not having an effect on the health, safety, and welfare of anybody.
So you're starting to get the theme of where you might care now,
Right.
or where you might want some controls.
And the house wouldn't prevent you said it's in retail?
It's a commercial office.
Commercial office. The house probably would prevent other commercial offices from developing in the
Right,
area.
and they have right next door. Nicholson, right? Yeah, Nicholson.
Yeah. And they could put an office inside that
That house, if they can get. the
and just leave it still the same,
Right.
yeah,
Like down, couple lots
Right.
down, they've done that.
exactly. Yeah.
And they've done that at
But-
Catella where Shenandoah is, that
Right.
basically converted those.
Right.
But it seems to me that, again, over time, that will correct itself over time. I mean, would somebody buy that to live in it? I wouldn't, okay, I mean, on that corner, but hey, at the right price, somebody would, and live there. And likewise, for an office, it would.
Yeah, or at the right price.
At the
someone
right
says, "Oh,
price,
I'm gonna
an
put office
attorney
there."
or somebody would come in there and say, that might make a neat little single, a single person accountant office, somebody just, you're not gonna have,
A dentist would go there, like they have.
not
down
anybody that has, more than one or two people working there, they won't have the parking for it. But is that really something that we need to try to accelerate? I mean.
Well, I see it more in the case that Victor was talking about, like having an incompatible use in a residential zone as something we want to encourage to go away quicker than
Well,
than
but
that.
I guess, do we? I mean, why? I mean, okay, we go back to Monty Collins. That type of property, it's now residential, he's an industrial use. And why would we want to push him out? I mean, why? We want, eventually, we want that, yes, we eventually want that to be all residential. And the market will push him out in time. I mean, death alone will take care of, part of the problem. The heirs will, they want the money, sell the business, and then there you go. But again, that's,
I was thinking more along lines of existing R1 uses, to have a non-conforming use within an existing R1 uses, not what
we
we're
don't think we
seeing
have
over
any.
there.
We don't have
Well,
anything, do we?
I don't know if we do, but I think we have to look.
We have an R3 place in the CG zone. which is behind Flame Broiler, the little apartment building.
Oh, yeah, you do,
Yeah.
It's funny, right? Has an office building in the front and six
Yeah.
And-
units in the back.
Right.
But that's fine. I mean, I don't have a problem with having that there because eventually the market will
That'll
make
all-
it more profitable to have a commercial and residential, and it will go away. I'm talking about
Right.
having an established R1 zone with a non-conforming use in there, maybe a business or something
Yeah.
that's creating noise,
I
extended
can't think of
business
anything in the
hours.
city, no.
Well, I'm not worried about any
Astoria,
particular
no.
site. I'm trying to, have a general plan. So,
R1s are pretty good.
no, as far as having something like Monte Collins and having residential come to it, that's coming to the nuisance.
Okay.
And if you come to the nuisance, you get the
Okay.
property at a cheaper
Here's
rate,
one.
and you gotta deal with the, what you
We got a
come
bar
to.
behind me.
Catella, on Catella, between Reagan, between Reagan and Los Al Boulevard, I believe, there is a no, a little farther down.
Further down.
Farther down, between Reagan
One
and
that looks like a
Bloomfield.
motel.
Yeah,
Yeah.
there's 3 units in there, or three?
Six, I think, 3 on
Two-
each side.
3 on each side, yeah. On Catella, right
Oh,
right
yeah.
on Catella, just
Uh-huh.
sandwiched
It's
in
like a
there.
motor
Driveway
lodge.
in the middle,
Looks like
yeah.
a motor lodge.
Right,
yeah.
and totally non-conforming,
Desert.
and would be great for another office, and eventually, that's exactly what will happen
Yeah.
when I don't even know who owns it, but,
When investment in residential is
exactly.
or it costs too much to
And,
rehab.
and it will happen, but do we need to put them under a
No.
timeline? And why would we do that? Because you don't know, I mean, I don't know, to me, it's a taking. I just think the amortizations are,
That's not my point. I think when you have that situation, you have residential in a commercial or industrial, you don't have an amortization period because it will eventually become more valuable for the other use, and the market will take care of itself. I'm talking about a situation where you have an existing R1 with a non-conforming use in it. It can affect the health, safety, welfare. That's the one I think we need to put
okay,
an
but
amortization period on.
So you've got residential,
Well-
most intense, commercial, then residential, well, R3,
R1, R2, R3,
If those are
PI.
your layers, you're trying to create kind of an incompatibility.
But there's already some incompatibility because of the zoning, like noise ordinances and things like that are in
Right.
place. So a business like that, that's a nuisance, the neighbors
They're gonna
can
be
be calling the cops
gonna
on
be
them, and
gone.
they can come and they can cite them, and they can, that kind of stuff can be happening without having to, they can be motivated to go somewhere else without having to.
Fast food restaurant behind your house.
exactly.
Right.
In the Highlands, there's the
I
Mobil
said that.
station behind it in Seal Beach, and they made them put a door in because it was so loud there. So,
Right. I just think that the market will take care of it. I think our duty is to provide the framework, provide the zone for the long term. And if it happens sooner, that's terrific. But it's like the, where DeVita is, okay? And that one, they came in looking for a commercial office zone, and we said no, because we didn't want any more medical in there. But they could go in there with their restaurant. We had them make it a retail zone.
Yeah, it was gonna be a melting pot.
And that goes, it was gonna be a melting pot. And that is not just that front part, it goes back 3 more acres back there. All that storage is on the same lot. So that's 3 acres of retail on a prime frontage that will probably never happen. That storage is gonna be there for another 30 or 40, and it'll be there forever. And, well, not forever, but a long time. But at some point, when it goes out, some planning commission is gonna say, wow, those guys did a good job, 50 years ago in zoning that.
Maybe, or there might be
Maybe.
so much traffic that they can't
They
actually
say no,
move
and then in which
at
case.
all on Catella and say, who made all this retail and brought in another 70,000 people?
We're
Yeah.
gonna have hover cars and stuff.
Yeah.
Oh,
Yeah.
okay, so we're good.
It'll be the new transit.
Yeah.
Back to the-
I'm
as it
looking at
goes
all
down.
this retail and extra parking,
But
people
that-
in and out, I'm
but I
like,
mean,
I
but
can't even
that's-
get here in
But
15
that's,
minutes.
to me, that's the stuff we need to be,
By the high school, you can't
that's the
drive
stuff
either.
we do. I mean, is we provide the zone, and then when it happens, you're not
The drones with the.
forcing somebody out and taking their life savings and everything else, and creating a bunch of ill will, and, or creating problems, you know.
Next
for
door.
Like these people can't get financing. And if that's completely empty, then yeah, it ought to be retail. Yeah, it ought to be retail. And he'll find a way to put retail in there. If that's what we want, he'll
That's why you
find
got
a...
a bargain on the land. 'cause
Exactly.
It was
Be-
retail.
Yes, and so he'll find a way
I
to do
mean,
that. But he can't
dropped
do it if
like
there's an
6 million.
amortization. Yeah, but he can't do it if there's an amortization. He's kind of, you know, so, but the zone will, the market will allow it. So, anyway. Without beating the horse too long.
All right, so where are we at on this?
Why doesn't staff ask specific questions of us? And maybe that'll kind of get us,
I have.
okay?
I've tried to give you examples and ask you what your real goal is. Do you have a desire? You just adopted a new general plan. It was important to you that uses change. Now, do you want to enforce those changes?
We're going to be working on the zoning here next year, I'm assuming.
You've worked on some of them already. Yeah, they're coming to you in pieces.
I just don't.
Okay. This is part of the zoning, the non-conforming uses.
It's a section of the zoning code,
Zoning.
yes.
Is it before things that we should be doing first, or do you feel that it's in their correct position?
I don't think that it's before, that there's anything we need to be doing
Okay.
before this. I think it's kind of important, since we've rezoned these properties,
Okay.
They're fresh in your mind.
that
Can,
they
can I-
know, and to, because problems are gonna come up, we should have the code fixed to know how to tell people to
Okay.
address what
So we need to look at how we want to do any type of amortization if we do, before we get to the rest.
Well, and it's not just amortization, right? It's also expansion, if people want to change a use, and so there's more to it
Can
than,
somebody add on
we've been
to
talking
it?
a lot about amortization
But,
tonight.
but that might accomplish what amortization accomplishes too. I mean, you either not allowing people to expand, and that can accomplish the same job as having an amortization. So if.
Right, but when realistically, we told CrossFit they couldn't expand. He expanded claiming he didn't know, and then we let him stay till the end of his lease.
But-
So it's not really working.
Well,
But it is.
we didn't
No, it
have to
worked.
let
He
them
didn't-
stay.
He
Right.
expanded without
Yeah.
permission. I mean,
That was-
obviously,
that
anybody
was-
can.
Action that we
Let me
took.
give you a good example. With a good amortization schedule, I would send a letter to our next door neighbor and say, clock starts now. You have 30 years.
Except for him, we'd probably say you've abandoned your use.
Well, yeah, that's
say
true.
he's abandoned.
30,
That's true.
he has 30,
But
30 years to keep,
If our amortization schedule said 30 years, yes.
but 30 years for what? To be able
From the
to,
date I write him the letter.
To change the use.
he has already, that's been changed already zone-wise from
Yeah.
off,
The
well,
zones
industrial
changed
to
from
commercial
office to
to,
commercial.
And that's if he
commercial
hadn't-
retail.
Hadn't abandoned the use, right?
So, as an example, for that property, based on what I was saying earlier, he wants to put retail in there. I'm assuming that's why he bought the property.
He'd be happy if he could put an office.
He wants it to be
per se.
Oh, he wants to put office back in there.
He would be happy, but yeah.
Now, but if this actually stated that when that property sold, it now becomes retail property, there's no issue with,
Again, I've never seen an amortization period based on the sale
but that would have taken care of
of
this
the
issue.
land. I would have to do
No,
legal
the sale was
research.
before the zoning was done.
Yeah, that's true.
The sale was done before the zoning's done, as the general plan was finishing.
Who, maybe we could get some direction here. We need to start focusing. Who would be in favor of an amortization period, and who thinks that we should have none? Who thinks we should have no amortization period? Art? Anybody else?
I'm not decided yet, actually.
Yeah,
on
I
it,
think
to
I'm
be honest
not
with you.
decided
I-
yet
I-
either.
well,
Is
well,
there
I
a
think
liability
there's
from a legal
merit to it.
standpoint with not having an amortization period?
Only because, again, the code wasn't finished, but if the code was finished, then it would have been a clear-cut decision at that point. I realize it wasn't, but let's just, because you said it was a mess, but let's just say that everything was in place, and the land sells, and it's now retail. Done. If the code was the way that we're talking about, I'm saying, that didn't happen that way. That's a really weird thing, because it wasn't finished yet.
The general plan was done, but the code.
Right, but right, but so that was a strange deal, but But had it been in there, that if the land sells and the zone has been changed, then it's pretty clear at that point.
Okay, if you had a CU, I'm just having trouble with that, because CUPs run with the land.
Is there a CUP on that?
But see, that's.
I know that's one example, but again, I'm just trying to weed out and understand where.
But I think it's easier if we focus on zones
Yeah,
than parcels.
Victor he wanted to start at the residential. When you have a residential zone, an R3 zone, and you've established that zone, and there's an existing use, do you want it to disappear?
And how long?
Yeah.
And that's basically, would be
You
a lot of
want to have
validity to
shelf
that.
life
Yes.
to
No.
that use.
I am in agreement on that.
No, not talking contiguous use. We're not talking where the R1 or R2 or R3 borders a PI, commercial. That's different. Talking wholly within the R1, R2, R3. That's my.
Within that zone.
Yeah, something
Not
bordering,
bordering.
something bordering another zone wouldn't be non-conforming.
That doesn't.
They're just
In
bordering
the
zones.
R3 zone, across Sausalito, you have a brand newly changed zone. You have Monte Collins's property, that is now R3. You changed it to R3 because you really thought across Sausalito, which was existing residential, was incompatible with industrial, and you wanted to square off that residential zone.
Right.
But Monty's not disappearing. Would you want to force him to disappear? Would you want to force that use to one day cease?
No.
Because it's incompatible.
That's not what I was
That's
putting
not your
forward.
intent.
No.
Okay.
Because my intent would be if somebody was in that R1 zone or R3 zone, an incompatible use in that zone now, not to project, I know what you're saying, that it's now R2 or R3, but that's not established yet. So what my vision was, does not apply to that because it's not an existing chance. Mine would be in an existing R1, R2, R3. And I know that's not making sense because it is existing now in a zone that way. That's not what I had in mind, because I was thinking of the health, safety, and welfare of the people. Now, if Monte Carlo's, somebody wants to buy and continue that use, I'm not sure I would be in favor of putting an amortization period on that.
If he closed down and he abandoned the use, and for 30 days it was vacant,
Abandoned, that's different.
would you want anyone else to be able to open it?
Well, if he's abandoned the use, now that triggers a different,
Only if you write it in your code.
yeah, once it's
Yeah.
abandoned, I think that we could, I would feel good about putting an
And
amortization
what is
period on it.
abandoned?
Well, no, yeah, that's
30
true.
days, 60 days, 90 days.
And keep in mind, abandonment means you get into a commercial, like a market we have been in. I think we're coming out of it.
Rite Aid, have they abandoned
Okay,
the use?
okay, yeah, use Rite Aid where West End was. Okay, that very difficult property to rent. Okay, it's been for rent. Technically,
They have not abandoned the use because they've been trying to market it.
okay, so if that's the
In
caveat,
bad market, it's hard to enforce
Right.
that.
And one of the things the new code will say is that abandonment, we will give you notice that we consider the use to have been abandoned and give you the right to appeal that decision, so they can come in and say, I have not abandoned the use, I'm the property owner. I've not abandoned this use. My tenant, went out of business or something because of the recession, and I've been looking to replace it. I've never meant to give up the rights to use as industrial property. So,
Right, but that's different if he had a fire in there and refuses to repair it to lease it out.
well, yeah, but
That's egregious. The economy's not an egregious matter. But if somebody's absolutely refusing to rehab their building to lease it out, that's pretty egregious.
so going back, so answering that question that Stephen just asked, we changed the zone. Do we want him out? And if we want him out, how soon do we want him out? Because I don't know that I necessarily want the guy out, but I eventually want all of that to be retail.
You do want amortization.
So, no.
Yeah, I was just gonna
No,
say.
no, I don't, no,
40 or
I want it to happen naturally.
Right, but
I-
if you set it at 40 or 50 years, you figure out the life cycle of an individual owning a business. Okay, yeah, they may pass it down to their, children or what have you, but for that guy, when you start the clock at 40 or 50 years, he's pretty much going to be probably done with that unless he was to pass it down. That's it. So now you're basically taking that option away of passing it down and saying, okay, at a 40 or 50 year 40-year time frame, by that time, we feel like we've given you enough fair notice at least to know that, hey, this is going to be this by this time.
And I guess only thing I'd say to that is, do you really care that he ends up being there, where it stays that way for 50 years or 75 years until eventually it either falls down and then it can't be rebuilt? The idea is that eventually it will happen. Why do we have to expedite it in any way, shape, or form? Why is that a concern to this city? To the city, when the city is going to be here forever. I mean, for us as individuals, we think in our own lifetimes and stuff like that, how long it's going to be for, yeah, I'd like to see it happen, but I'm thinking in my lifetime. No, I'm thinking
Generations.
city, yeah, I mean, it'll eventually happen.
Well, if we don't put a time on it, somebody might come in, eventually it's gonna become valuable to a developer, and he's gonna come in and offer a price that's gonna be attractive for money to sell, and then it will,
And it will happen.
and it will expire on its own.
Yeah, and I'm kind of inclined to agree for a couple reasons, because I think, because of the enforcement thing, because I don't think that we ever have, I don't know if we ever have, but I don't know that we really will enforce on it. And second, I believe that just by changing the zone, we've already created an environment that's promoting that.
Right.
And that's going to create the attraction for someone to come in, and then over time, we either set a time period on it that's, 30 or 50 years, which is a really long time.
So you get,
And this, well,
I've been here for 50
but between now and then, things may change, right? That property may get rezoned back to something else again, right? Because things change. We'll all be gone, and someone else will have a brilliant idea on what the city should look like 30 years from then. So, but I think the market forces are going to end up being more
It
powerful
will be,
than
yeah.
amortization schedules.
Yeah, kind of feel that way.
And the other things are code, if you have an inappropriate use in a residential zone, bordering houses now and it's industrial, he's gonna get nailed. It's gonna be cumbersome for him to do business there. It's gonna be, he's gonna be motivated to go
He
elsewhere.
did, by you. It's now a bank instead of a hamburger stand. Right? It's the same, that is the exact scenario. I mean, look how quickly that happened, if you think about it. It took maybe
Well,
8 years, 10 years,
Seemed like a long time, but yeah.
but it was like yesterday that you were out there.
Sure, and it did go. I had to go through a couple of different kinds of businesses, but then,
You got one that's compatible.
yeah, something that's
There was,
definitely much more.
And we
compatible.
didn't push him out, we didn't, I mean.
Right, and I didn't.
No, but the
honestly,
market
I
did.
didn't. I worked with those businesses in the spirit of compromise, right,
Yeah.
with both of them, and tried to be neighbors with them, because I'm kind of like, well, who am I to tell them what to do with that property? That was there when I bought the house,
Right.
right? And I knew how it's commercial; it could turn into something else. So, I could fight against it and try and get a fair shake and make sure that we weren't getting, the short end of the stick, but.
the way it sits now, though, is that you have to make the assumption, and what you're saying is that on a time scale, it doesn't matter. At some point, you feel that someday, many years later, it may change. But if there isn't anything there, then a place like Amani Collins could continue the way it sits to be, whether it's backhoe or whatever other industrial
Well,
type
can't get
of
more
application.
intense.
Can't get more intense, but it could continue to operate that way. So it just depends on if everybody sees fit that it's okay that it operates that way until the market determines that it does? Or do you want that residential a
but it'll-
little quicker?
But it'll stay like that anyways, because if nobody wants to buy that property and turn it into
For
residential,
residential, right.
just because the amortization schedule hits, doesn't, all of a sudden, somebody's not gonna say, oh, I'm gonna buy it now. I mean, if he wants to sell it, if we make a 30-year amortization schedule, he wants to sell it in 20 years, if nobody wants to buy it,
It could
Houses
affect,
aren't just
it
gonna
could
pop
affect
up
the
there.
cost of the property, whether we do it or don't until two. That, the actual, the sale of the property price-wise could go up or down according to how we handle this situation.
correct.
It could be an advantage or it could be detrimental to the sale of the property on how we handle this.
Right,
Ultimately not
but
the
you could
city,
say the
because
same
zone is
thing-
still there.
Ultimately, that's the same,
Yeah,
but
but
to the
you could say
individual
that-
property, to the individual property.
But you could say the same
That's
thing
why
to
you
the
can't
property
buy it.
next door to him, right?
Oh, you,
And he
absolutely.
could be affecting it. So
Absolutely.
it
There,
kinda
there was
goes
there was, in Cyprus, there was a street, and it had horse property on the street. And they changed the zone because it became more congested and everything else. They said, okay, that's it, at this point, no more, it's not horse property anymore. However, people had horses there, so they didn't just say you have to find a new place for your horse. Basically, it just went that however many horses you have or what you have on the property is fine. When those horses pass, they can't be, you cannot put another horse on the property. And so eventually, over time, all of that property became regular property. There's no more horse property at that point. And that's, kind of what we're trying to get to at this point, where you say at some point that you get to this point where you've made it a certain zone. At some point, you want that zone to be that product in there, if it's residential or retail. So we're trying to define, do we put a timeline on that or do we not? And it sounds like most of us are saying we do not. Do we put one? We don't have an example for residential right now, but I agree with Victor. I don't know that it's a bad idea to actually put it in so that it doesn't happen in the future, with what you're saying about having a non-conforming in a residential. We don't have an example of that currently in the city.
You know,
How would we end
but
up with
I think,
that?
I think, I've rethought, since John spoke, that we don't need to have an amortization period to deal with that because we have codes. And if there's somebody creating a nuisance in a residential property, running business or something like that, then the codes can handle that. And we don't have to put this amortization period on it, which would be extended anyhow. If there's somebody creating a nuisance on your block, you don't want to wait 20 years for it to amortize out. You want to have code come over there and deal with it now. So I've changed my original position. No,
He thought about his neighbor noise.
I have. I don't think it's necessary to do that, and I basically think that I'd like to let the market control how these properties we're talking uses. We're not talking parcels, and we're not talking buildings. We're talking uses. I'd like to see the market control when they expire, no matter what zone.
So that's it for amortization for uses, not on the other part yet.
Right, just uses. We're just talking uses now.
You talked about the building that I had to recuse myself from on the CrossFit. I don't understand how you're talking about the amortization for this. Or how that could affect. I guess I'm really confused on that
We're
part.
talking about the expansion of, that one is expansion of
expansion. We haven't gotten there
non-conforming.
Okay.
It's part of the remember, we're not just talking amortization, we're
Yeah.
talking non-conforming
Well, yeah.
use in general, it's just another part of
So we'll just stay for the
non-conforming.
uses for right now.
So right now,
Now
we're
it's
just
amortization.
talking
So the commission-
amortization.
Seems to.
Right now, as I see it, the commission can't find a reason to have a schedule, so far.
Correct.
But I think you do want to restrict intensification or expansion.
Yes.
Yes.
I do.
Okay, in some way. Okay, what about remodeling without increasing the size of square footage or intensifying?
So can
Is there
we,
case law on
Can
that?
someone modernize their
can we,
building?
can we stay focused just a little longer on
Amort-
dispense with amortization and then move to the next
Sure.
non-conforming stuff? Expansion and all that. Is that okay?
I think that, I'd like to stay focused on one topic at a time, I think that would be helpful for me.
It's hard.
So no
It is.
schedule, but no increased intensity or increased footprint.
Right, that's what we're hearing so far, I just want to summarize this.
All right.
Now, what about someone being able to remodel their site?
Well,
Are we,
is council ready to move on to that?
Well, Art said he wanted to still focus on.
well, I mean,
the
is that, so if we ask the same question we just asked about an amortization schedule, should we or should we not? Should we answer that question? Should we or should we not? So
Yes.
Uses.
for her.
I think we're in agreement that we're
I
not.
thought we
Not.
For
did.
uses.
Yeah.
For
Gary, you have
uses,
anything?
yes,
Yeah.
not.
Gary hasn't said a word all
Gary's
night.
been quiet down there.
I think he's in agreement, though, with no
No
amortization.
amortizations.
I think there's something that kind of, for some weird reason, I feel like I want to have it, but then when I think about it,
Yeah.
I'm like,
The
I really, I
concepts are
don't know
out
that
there,
it's,
but you can't quite.
Yeah.
right, I don't know that it's gonna do what we want it to do anyways. I think the market is gonna be more
In a
effective.
fully developed
Um,
city, you find, in a farming community, maybe. In a community like ours, it's difficult to get your hands on a reason why. I see that.
Yeah, okay. All right, so now.
Okay,
let's
so
move
I think
into-
we're good on that topic.
Okay, so no amortization schedule, and we stay with the standard provisions that you can't increase the size of a building or the intensity of use.
Correct.
Right.
Correct.
Right.
Right.
And that's what brought up Steve asking,
About remodel.
if you're not gonna increase it, can you like totally redo your building?
Usually, the ordinances provide that there's a monetary limit on it. Because the problem is, if you go in and you completely, let's say you do $200,000 worth of improvement to the land, and then somebody later, maybe it's not as important if you don't have an amortization schedule, but later on somebody does say, I want to, or they do put in an amortization schedule, then they go, well, wait, I haven't gotten the value out, and I get a longer period of stay. The other way, even without an amortization schedule, that comes into play is if you say, let the market forces decide, well, you've got that little R1 house in the wrong zone, but now you've completely modernized it inside. The market forces will be harder for it to buy it out because you've put so much improvement into it.
But that's on the person doing the remodel, is it not?
Well,
No, well, if you're saying that the market, no, because the idea of the city, the idea of non-conforming uses, the general law, Victor, when you're talking about is there case law? Case laws depend on what you write in your ordinances. But the general provision, the general idea between non-conforming use statutes is that the city wants the use to go away and not expand.
Right.
That is the idea, to get rid of the use that's not there. Therefore, most ordinances, and I think ours already provides it, maybe one of the clearer provisions, is that you don't allow repairs unless it's there was an earthquake or, some fire or some sort of damage, but you don't allow just general improvements above 25% or 50% or something like that.
Yeah,
What's
this one for Tustin has some section on that. They've got 50% of the assessed value.
What's interesting, I don't know if they have an amortization schedule, but, because then it does make a lot of sense, obviously, if the guy's got 10 years left and he's throwing over 50% in, that's probably not the best use of his funds. But if we're not putting a schedule and we're saying that we're letting the market determine that, then at the current time, if the remodel, if the use or the owner of the land feels that it's necessary for the current market condition to remodel his property for that use, then again, we're kind of going back in and saying, no, you can't do that, but yet that's what he needs right now for his business to be successful in the current market. So if we're saying let the market dictate at some point in time, then that need won't be there for that, whether he remodels it or not. But at that given time, he feels that it's necessary to grow the business that he has at that current moment. And then we're telling him he can't do it, or he can only put in so much to do the.
Well, I
Yeah,
think
we'll
we're
work-
balancing between letting someone expand
There was no, we already said no
Right.
expansion. I'm
Which we-
saying a remodel
we said
within,
no.
within the walls and confines of what it is.
Right.
No expansion and no intensification. But now we're telling them you can't remodel to make your help your business be successful, let's say.
But you said grow your business, and we don't really want it to grow.
I'm saying not grow in size,
We don't have a provision in there?
but certainly a business owner is going to want to grow his income.
And we also want to we don't want to prohibit remodeling, and then we get a building that's a visual
Well,
blight because they're
Because
not
they can
allowed
only
to paint.
spend 25%.
Right.
There's a
I think-
danger there.
Yeah, I
And we
think,
have to distinguish between remodel and repair.
And are we talking the outside or the inside?
I haven't decided.
we haven't gotten there yet.
That's what I'm kind of confused.
Well, let's
Yeah.
talk about expansion. We're talking about expansion of the use, so,
We said
No,
no.
we said no to
and we
that.
said,
Wait,
right,
no,
and we said no expansion. And I think what has to be clear is like with the we'll use cross.
I was assuming, okay, maybe we need to step back, because maybe I'm not clear. Expansion of the use, I was taking it with the CrossFit situation, that they can't expand into another,
And that's the
That's what I'm- yeah.
yeah, and that's the dilemma,
Or
okay?
add on.
The codes, the code, the
Accessory
existing code
buildings.
talked
Right.
about within the four walls, more or less, but when a non-conforming business comes in, it's the suite that they're in, it's the space that they're in when they come in.
That's it.
Whatever that is what it is. Taking the wall out and going to the internal expansion is still an expansion.
No, that's
Sure.
what
And
I'm
that's what
saying
you
is
want,
not,
that's what you want to avoid.
is not allowed.
Right.
That's what I
Right.
was
Right.
suggesting.
Okay,
So-
so are we looking at the internal expansion of a business in square footage? And
Yes.
that's- Okay, I
That's-
thought we said no to that.
We did.
Okay.
He's just making it clear.
Make it
Yeah.
clear, because we're
Okay.
not
That's
talking,
a-
that's
that's
the,
a-
And we're not
expansion of the-
talking
of the
that
use.
as remodel.
that's the ambiguity we had in the other one.
But that's not, you're not talking
And
then
the structure.
remodel.
Right.
And I
You're
don't
talking
think your code
expansion.
actually, your code, the code, our code, right now, I really keep trying to distance myself from this ordinance.
Well-
Right now, the code provides that a non-conforming structure that's destroyed to the extent of more than 50% of fair market value, may be restored and used only if a CUP is first secured. So if you, any destruction up to 50%, you can just repair, but if it's more than 50%, then you need to get a CUP.
Internal.
But they can deny a CUP.
That's correct.
Right.
Right.
We
thought it
don't
wasn't.
appear to have
Correct.
anything in our code regarding remodeling, bettering the building, be it inside or outside with the dollar limits. There are codes that have those.
When I was talking about remodeling, just so I'm clear, that I was referring to remodeling within the current structure, not adding on
Right.
any,
So-
any
Well,
square
I
footage.
think we need to make a distinction between a use, right, and
And the structure.
And a
and
structure.
Because
There's-
they're two different things. And sometimes the use is going to occupy some square footage, so an expansion of the use would be going from 1,600 square feet to 2,000 square feet.
Right.
And that may not require any expansion of the structure, because it could be all internal, like taking down a wall in a business park or
Still
something
in-
like that.
That's
right?
still internal
We're saying
expansion.
no to that non-conforming use.
I'm saying, I think it should be no expansion of the use.
I agree.
And it
So
should be
we've
no
got
expansion
no-
of the structure.
I
But do
agree.
we want to allow people to maintain their structure and do a facelift?
I think they should be able to.
So now when you talked that, you just said the outside, correct?
Yes.
Yes,
Correct.
no expansion,
So question
internal
on that
or
one.
external.
When we looked at the outside of the structure, we have Madera's strip mall over there, they came to us. Is that not the requirement for a lot of these, or can they just arbitrarily redo their outside appearance?
They had an old site plan approval, if you remember, and they were changing that old review, so that had to come back to you for alteration or modification.
But they
It
had to
wasn't
do a
because
site
they were adding
plan,
square footage.
but they
No,
had to do a
no.
site plan review in the first place.
The first time they were built, they had a site plan, but then they changed the architecture, so that site plan came back to you.
So
Well,
that
one-
would still hold true.
One of the things we could do, or
It's a fire.
comment on this if we could, if it's a non-conforming use and they want to remodel, they have to come in front of the commission for a CUP. That would be one way for us to regulate, or at least look at what they plan to do and determine whether it's expansion or,
Conforms with what we
well,
want
we did that with
aesthetically.
the gas station down by the starting gate.
The one that changed overnight?
Well, we did that on the sign.
Right, but they
Signage
wanted
and
to do a
signs.
lot of other things to that, and we
Went from
basically.
76 to Chevron overnight?
You're thinking about an overall approval when you were on the commission on time ago. I think, yeah, you're right.
I mean, that would give us some control over the remodel.
Do they have to, well,
Yeah, can we take a recess real quick? We were talking
talking about
about
remodeling.
remodeling. And here, I'd like to find out from everybody here, how much longer do we want to continue this discussion tonight? Because I don't know that we're going to get to the whole thing.
Oh, we're not,
No.
So, do we want to go, like, are we getting close to thinking we
Can
did enough for tonight,
Can we
or?
focus on, did we make the decision on the internal? We're not going to expand the uses,
Right.
and we've
Yes.
already got the, in the inside done, so can we just finish the outside and then call it a
What
night?
did we do with inside?
We gave it to you.
Inside is uses, so the use
No, I mean,
can't
we've already
expand.
talked about uses. Can't
Can't
expand.
expand.
Right,
Yes.
so that's what she means when
remodel.
she's talking about inside.
So now we're talking remodel. We haven't.
Victor was asking about
Right.
a CUP for a remodel. But
Well-
I was going to pose the question, when you
What is
remodel,
intensified?
whether it's inside or outside, do you not need to come to the desk for a permit anyway?
Only if they had a site plan review that said a certain style of building. Like the one over here, Madera's, it said that it had to be
That's if you go out.
Spanish style. And that's why we brought it back to you.
No, no.
Okay.
You have-
So where does that original site plan review come from?
From the planning commission, I mean, years ago, many years ago.
why,
Every
I think
building
this is
in the-
why
in
did
the
it require a site plan review?
Oh, because when you build a commercial structure, you have to get a site plan review.
So every commercial structure in the city has a site plan review?
No, because some were built before 1960.
Okay, so we can't rely on that?
Right.
Okay.
But when you say, I don't understand, when you're talking about
So
existing-
I think we want to let people improve their property to some extent. Otherwise, we're going to end up with really bad-looking properties, right? Mm-hmm. I think
But
we
we
just
wanted
need
You
to,
still have to maintain the property in accordance with the property development standards. I mean, nobody's saying you can't, paint and do that.
Can't repave your parking lot.
And you would, the building codes would require you to maintain it, for your nuisance conditions and things like that.
Right.
Same as the
And do they,
business in an R1.
and is that also with color? That it's the color that they stayed within, or can they arbitrarily just change the color?
If it's a single family house.
No, I'm
Or,
just, I'm business.
like a
I'm
commercial.
Not business, family.
Right.
Just wondering if you can. Yeah. I'd hate to see that purple one day.
We don't have design standards.
We don't have color.
So that's something we should think about.
Although a
doing.
site plan review does do design of the color.
But painting doesn't trigger a site plan review.
Right.
No, so, yeah, and I know that became an issue in the city a long time ago when Miami Vice was very populous, and I've really dated myself as to how long I've been doing this, that there was Moore Park, which is very much Spanish style, and somebody decided that Miami Vice colors were really cool,
Yikes.
and the city went crazy because they had nothing in their code that said, you can't paint Miami Vice colors, you have to stay within these
So there was a lot of pink and mint green.
guard palettes. So that's another section, needless to say, of the codes of design standards. But right now, unless it requires a site plan review, you can't stop somebody from painting their house or their business.
That's a bigger discussion than
Yeah.
non-conforming, I think.
Right, that's not tonight's
That's a different issue.
discussion. That's definitely
So
not
we're on
tonight's.
the non-conforming uses, they cannot expand beyond where they're at internally.
Do we put a limit on remodel?
So now remodel.
On internal. I thought we
I mean,
did.
internal to their space, they're not expanding.
No, just
Can they,
within the walls or the exterior, so the exterior or the interior, but no expansion. When I say remodel, meaning whether they do a new facade.
Well, generally, the
on the-
use is inside, isn't it? I mean,
But we're talking both, I think.
But the
We're
use
talking
drives
about-
parking.
right.
Yeah, the use is the total lot, the total parcel,
Yeah.
because it affects parking, signage, everything, right?
But when it comes to the outside of the building, that's where I get more concerned. Especially when you're talking putting up a facade, a signage.
Signage is different. We have a section in the code
Yeah.
for signage.
But, yeah, but these are things that, the outside, do we want to have some control of that? And I would think yes. I don't want them just, I don't
But I
care if
think
they
we do in the
they're
code
same.
already, do we not?
what can they do to the interior of their non-conforming space, which is what we're talking about now? Remodeling that,
I don't have an issue with putting a limit on an interior remodel for somebody that in non-conforming. Again, we've put no timeline on it, and we think that the market's gonna dictate. If the individual feels that the market dictates he spent a ton of money remodeling his place to make it look a certain way for his business, then again, why are we putting a limit on that?
that's my question, or
Yeah.
do we?
Okay, but does that remodel?
As long as it
include
doesn't
walls?
expand,
Right.
They may, so.
I'm trying, I mean,
Or
I'm
intensive.
just trying to
As
think
long
of what,
as
a-
they're not expanding.
Or
yeah,
intensive.
what do you care? I
But
mean,
does
he
that
can't,
include walls that require electrical components? Are they doing it
Could.
safety-wise? I mean, those are the concerns
Those are all required
that we
buildings.
But
should
that's
all.
required
These would
anyway.
require building permits
Those all
anyhow.
are all
Okay,
permanent.
then-
Right,
then-
and they're gonna have to come up to all the current codes, which are ADA.
Right.
If we don't
Everything.
allow them
That's
to
not-
do that
that's
stuff,
already
then
in
they'll
the
do
code.
it, but they won't do
Illegally.
it. They won't get a permit on
Right.
it, and we'll end up in,
Exactly.
I think all we
Let
need to
them do
worry
it.
about
especially for
is
internal.
whether we're
As long
putting
as you
a monetary amount on it.
Right.
And the rest of it is handled by the code as far as, that's why I was asking about permits and whether or not you're gonna do a remodel and you're gonna do any of that stuff, you have to get a permit anyway. Technically, you have to get a permit if you change a toilet out, I mean, technically.
But am I allowed to issue that permit? That's what I'm asking the commission.
I-
Do you want me to issue a remodeling permit?
I think if it meets the current code, I'm okay with that.
Okay.
I am too. Because we don't want visual blight.
Remodeling should be.
And again, from the exterior, so it's a good point that you make, you know, this may not happen in our lifetime, but while it is here in our lifetime, do we want it to look nice if it's being used for that purpose? And if the guy feels that changing the facade, as an example, the Madera's place just changed, they didn't add square footage that I'm aware of, they changed the facade. They remodeled and changed the facade of the building.
Okay, let's use two non-conforming sections and run that through. The house on Catella in Lexington,
Uh-huh.
would you like them to be able to remodel that house?
Why not?
Yeah,
Internally?
just
cannot,
asking.
well, the remodel, cannot expand the
Correct.
square footage.
No new square footage,
Paint it,
paint it,
If they
new
wanna do New
driveway,
kitchen, new bathroom.
new driveway. You okay?
even
Can
the,
they
he wants to
tear
waste
it
his
down
money
and
on
put
that.
a new
The
one?
highest and best use of that property is probably as a commercial property eventually. That's the highest and best, if he wants to waste his money.
So that's a
But-
good-
But that's his money to waste. if
so
he
that,
wants
that's
to
a,
make it nice
that's a good
inside.
point. Is that considered a remodel when she just said, can they tear it down and build
Well,
something
that's why we
else?
need to set some guidelines for that.
Okay, now.
Tear it down, build the same
Stay
size.
on this. Would you like Monty Collins to be able to remodel his place?
It would look,
If he's gonna stay there,
Yeah.
then why not have it
Yeah.
look
Okay.
better than it looks right now?
Just testing the waters to make sure you guys are thinking this and how it would be applied.
but if it
Not,
was,
not expand, but not.
Not expand.
so if it was torn down and it met code and it didn't expand, then we're okay with that even.
Torn down.
Why would you
But if
do
it
that?
burned
Would you
down,
tear it down?
No.
Do that again.
As an example, she just said, let's just say somebody has this wild hair that they see that place on the corner and they have this grandiose vision of what it should look like, and it's not that. So they buy it, they're gonna use it for the whatever non-conforming continued use.
It's a residential house now. You
I
said.
know, but you can use it as, it's actually zoned as what?
office.
Okay, and that's another topic, but let's just say.
What's that? So he's gonna continue to use it as
It's 1,000
office,
square feet?
even though it's
Maybe.
residential, right?
1,100 maybe.
Okay, so it's 1,100 square
So
feet.
he could tear it down and build 1,100 square feet, but it might have a different
Configuration.
configuration to it.
Is that okay?
I'm
I
trying to
think that's a
explain.
little more expensive than what I was
What,
thinking.
you know,
Yeah.
Right, that's
Yeah.
what
Well, no,
I'm saying,
why
that's a good
saying,
point.
But
Yeah.
in this custom one, they have a 50%, right?
Right.
You can-
Yeah, I think you could do
Partial tear down. Partial
Right.
tear down.
I like how this one says,
Right.
if it's accidentally destroyed by fire.
Because fire is never on purpose.
So
We're
where do
using
you,
good examples.
So they can rehab the property, not to, again, not to expand the intensity or the size, and they can't, they can't tear down more than 50% as part of this remodel.
Yeah, this is
Okay.
based upon assessed value.
Now I'm going to throw a real curve at you.
No, he's saying 50%
Oh,
of the
now
structure.
see.
That house is legal non-conforming because it doesn't have a two-car garage. Would you stop them from adding that two-car garage?
Based on the previous stuff that we gave you,
The
yes.
two-car garage. would
That's
be an
intensifying.
expansion.
No, because you have to come up,
Expanding.
Right.
when you
Yeah. So you
remodel, you
couldn't
have
add
to
it.
come up to current codes.
But he can't because you won't let him expand.
Then you can't.
Well, he's not zoned for, I mean, it's not zoned for that.
It's zoned for, well, he's grandfathered in as residential,
I know, but
remember?
that's our, again, that's one of our ways of kind of limiting.
So you do want it to disappear in some sense.
Well, we said that at the
Yeah, I
given
think-
time
I
that the
think-
market
okay,
dictates.
Look, I think the terminology is what's creating the issue. A remodel, okay? A remodeling is as long as you're not expanding the structure, square footage of it, can he tear down, can he level the place, follow the same footprint net? I would say no.
I agree.
I would say no.
Agree.
Okay, not put the same use in. Again, we get into structure and use, okay? And that's two different issues,
yes.
right? Okay? So
Definitely.
if he's going to tear down and build, but the use is going to change to the current, to office instead of residential, then yes. If the whole thing is now to change the use to a conforming use,
Yeah,
then we've accomplished that.
Yeah,
But if he's going to tear it
bring
down,
it
if he's
into
going to tear it down
conforming.
to build a new house, no, because that's not conforming for the for that
So you
property.
If he-
can't tear down
You
and
can't
rebuild.
tear down and rebuild.
If
I
it
agree.
changes and becomes conforming, if the use
If it-
changes and
it-
becomes
the idea is
conforming,
that
then he can do whatever he
The
wants to do.
nonconformity is the use, it's not the structure, it's the use.
Well, it can be
But
both.
then it becomes
Well,
conforming if he
Well,
changes the
If he makes it
use.
an office, then he has to provide adequate parking, and if he wants to add make it two-car
Well,
enclosed,
but right now,
That's
it
another-
should have a two-car garage, right?
if he
To
wants to
me-
keep it as a residence,
Right,
yes.
and it doesn't. So we typically wouldn't allow someone to
You
expand
can't-
or
Correct.
to
But
remodel.
you should be able.
Yeah,
But he
See,
should
I-
be able
that
to
one in
improve the
advance.
interior. When you say remodel, if you're talking about
Yep.
basically replacements of cabinets,
Sure.
carpeting,
I agree, should be able to do that.
Electrical, putting in can
update
lines.
his electrical,
So significant versus not.
well.
So you can do interior remodels and make facade improvements.
But no tear down.
But no tear down and reconstruct, and no,
But Art, so back to the no tear down, I guess this wouldn't even apply to us then because now we're not dealing with non-conforming. If he decides to change the use
Well,
to
then-
conforming,
Well,
then he would tear it down, but it wouldn't fall under non-conforming
Right.
anymore. It just
Correct.
falls under building to the
he's gotta
code
build to
Right.
the
of what the
office.
use, of what the
Right.
use is.
Yeah,
Right.
to a commercial standard
For-
related
for an
office.
office. And that may not require a garage, but he's gotta have enough parking on site for.
Good luck.
That's the issue, that's his
That-
problem.
Yeah, it
Well,
is.
that,
That's why it goes
that's
on
another
stilts,
section
right?
then of non-conforming of what
It goes
you
on
do.
stilts.
Another question,
with
I'm
those.
thinking, we're talking about footprint, we're talking about square foot. What's the formula we used for the storage? Because what if we say you can't increase the footprint, what's to prevent them from going up? Would that be an expansion of the
That's an
property?
expansion.
Yeah,
That's
that's
So
that's-
what
And
do
an
you say,
intensification.
We're not talking about expanding the footprint,
No, no,
we're
we're
talking
talking
about expanding the.
expansion.
Expanding
yeah,
the-
square footage.
Yeah.
Yeah.
All right,
Well, that's square
Okay,
footage.
you're giving us some things to
is
work
that for
with.
tonight?
It's not for-
This is a good time
It's a
for
burnout.
us to take a break.
It's a lot to think about, and they're concepts that just kind of float out there. that are-
I'm still ready.
Been some good
They all left
conversation.
bike night. I could stay a couple more
I don't
hours.
think we're done yet.
According to that date.
Are you
What else do we
are you
have in
gonna
here?
bring this
Might
back?
as well.
All right, so we're going to continue this?
Yeah.
All right,
So
so
keep
we're
it.
going
Please keep
to
it.
continue this to our next
Please
regular
keep your
meeting.
binders, and we won't give you any new
When's the
notebooks.
next meeting?
The next meeting,
What?
December 16th.
Wait, we can take these with us?
Keep your binders, we will send you an envelope.
Oh,
All right, items from the Community Development Director.
Nothing to report. Oh, your commissioner dinner.
I will
that'll
not
be
be
be-
able to attend.
That'll be, have you already RSVP'd for everyone?
No, I haven't, but I
I
will.
did.
It's my daughter's birthday that night, so
I'm in
You don't want to
Vegas.
bring her to the commissioner dinner?
I'm in Vegas.
She'd have a lot of fun.
she's going to be 13. I don't know that that's really her
Can you guys
speed.
bring it to Vegas?
So commissioner dinner is on the 9th, 10th?
8th.
8th? Thank you. 8th.
That's my exact.
Fun dinner, it's council's opportunity to say thank you to all of you serving
This
them.
will be the first time I missed it.
I'll be
So-
learning about CEQA in San Francisco.
I would have gone.
So and then Winter Wonderland at the Plaza,
I forgot the date.
that's coming up in 2 weeks.
That's strange.
God, I wish I had my calendar. So
this Saturday.
Small Business Saturday, shop local, shop often.
When is that? I saw that
It's
sign.
the Saturday after Thanksgiving. Friday is your super shopping day, Saturday's your local day, and then Monday's Cyber Monday, right?
Right.
That's
Yeah.
weird.
So Black Friday, Small Business Saturday, and Cyber Monday
You saw
There's a
is the
check.
way it's marketed by American
I
Express.
wasn't there.
All right, I think that's
Wait a
it.
minute.
Oh,
I think they put it in.
I'd like to invite everybody to come over to Precious Life Shelter, December 6th at 3:30 to 6:30. We do an open house. So if you want to really see what the shelter's about, we take tours through and explain the program to you.
3:30 to 6:30?
3:30 to 6:30, December 6th. And I've already signed up for Race in the Base. Anybody going to join me?
I'll be doing it.
February
Are
27th.
you walking?
I'm walking. I can't run yet.
I'll be in Big Bear.
But it's
day.
nice
How
to
do
be
you know
walking
this
around.
already?
Unfortunately, my son has a competition every weekend from December 12th to March, first weekend in March. I'll be there every weekend.
Been a pleasure, Art.
All right, anything else from anyone?
Everyone on TV now knows that.
Gary, anything from you?
Nope.
I gotta tell you something.
All right, meeting